Your Lordship's kind leave, Lord, the one contempt petition is coming up on 19, where the accused is the same. I also filed a contempt petition in respect of the same accused in respect of the adjacent properties, which relates to cutting of the trees. That is posted on 19. So my request is this also matter taken upon.
Kindly, my lord. Contempt petition, my lord. March 22, there was a direction to look into the salary disparities of the petitioners within 2 months. That was not done. We have filed a contempt. October 22, the state has requested 2 weeks time to file a counter. They are not filing. Salary disparities is equal pay, equal salary is not paid.
After 10 days.
My lord.
Within 10 days, it will be listed.
Much.
Provided you remove the office of this. Yes.
I'm the respondent in a writ appeal, where, my lord, the government has challenged the order of the learned single judge, wherein the learned single judge has directed to enter the name of the respondent in pursuance of the judgment and decree passed by the civil court. Now, my lord, in a writ appeal, there is an interim order. In the meanwhile, the government also has filed the RSA, wherein out of 5 RSA, 4 has been withdrawn by the government. And 1 RSA is there, and there is no interim order. My lord, since I have filed an application to vacate the interim order, the matter may kindly be taken up.
After 2 weeks.
Permission and contempt matter. The representative of the petitioner for payment of the contract amount, it is still pending. They have not still date not paid. Therefore, contempt has been filed. Clear the office
After 2 weeks.
My lord says, state memo, my lords, in a PIL which is disposed of, certain monies are deposited, my lords, in the PIL, where the monies for withdrawal of the same for construction of hospitals and schools, my lords, we need to seek permission of the court. I request the memo may be kindly considered for Monday, my lords.
Have you filed any application?
Please, applications are already filed. May I request?
My lord, contempt petition, my lord. My lord, the learned single judge directed to maintain the status quo, but till disposal of the suit, my lord. Instead of maintaining status quo, my lord, the respondent dumped the 2 lorries of mud in the road. It is very difficult to go school children, my lord.
Next week. Next week. Yes.
Lordship's permission, my lord, one contempt matter, wherein, my lord, the complainants, my lord, about 43 complainants, my lord, have been issued sale deeds, my lord, but they have not been put into position, my lord. There's some urgency. All of them are senior citizens, my lord.
After 2 weeks.
Lord, Monday, if my lord could.
Not that. Yes.
The learned single judge has passed the order restraining the construction undertaken by the appellant. And in fact, under the section 248, 1 and 2 of the BBMP Act 2020, proceedings has been initiated against the appellants. And confirmation order is also posted against that statutory is filed before the Chief Commissioner.
Contempt. Contempt. What is it? Writ appeal. Can wait. After 10.
Please.
Your Lordship, the appellant was working in the respondent company. He was removed from the job without notice. So I had challenged before the labor court. Labor court had granted back wages and salary, my lord. The same order was challenged before the single bench. Our single bench has reversed the order, my lord. Hence I filed the appeal. The appellant is unemployed. Any date, my lord, matter may be taken up.
After 10 days.
Please, much of.
Lord, there are 2,800 investors not waiting for refund in this case. Lord, the KPIT court proceedings was washed by the learned single judge. Lord, a repetition has come to be filed. Lord, any date, Lord.
So PIL.
Yeah, no, writ appeal.
Writ appeal. After 10 days.
Lord, a contempt petition, my lord, against the BBMP. There was a direction by the learned single judge to the BBMP to clear an unauthorized construction by the BBMP itself, and to hand over possession of a civic amenity site to the school. I have not had the chance of constructing on the civic amenity site, running my school for the past 12 years now. Hence, the contempt, they're neither filing their reply nor are they complying with the orders of the court, my lord. May I request for next week, my lord?
After 10 days.
And one more contempt similar against the BBMP, my lord.
One is good. After 10 days. Get given.
Lord, may I make a motion?
Till number 1, Mr. Prakash, HC.
It's for a 2 weeks time to comprise.
2 weeks. 2 weeks time is granted to remove the office of objections, failing which the writ petition shall stand dismissed automatically.
Seal number 2,
You want 3 weeks? 3 weeks, but then same preempt.
seal number 2,
Yeah, for
KN
request.
Subbareddy.
Request for a 3 weeks time to comply with the office of objections.
Same order.
Please.
Number 3,
Same.
Same order.
Three.
Same.
number 4 for
Public.
second time.
2 weeks. Same order.
Number 5. Rohan Kothari.
5, nobody is there. You are there in 5?
Rohan Kothari. Item 5.
5, same order. Same.
Number 6, GS Venkata Subra.
2 weeks time.
6.
Translated copies to be filed. Complied in a week's time, my lord.
Within 2 weeks.
Week's time, my lord.
Weeks time, 2 weeks grant.
Right.
But it will automatically dismiss unless.
No, my lord, almost ready, my lord, only translated copy. No.
Preemptory order.
Preemptory order.
I understand. Great.
Number 7, Mr. Supreet S. Mr. Supreet S. 7. 13 of.
Same order.
Number 8,
So may I request for
Ishan?
2 weeks time? 2 weeks time.
2 weeks time.
number 9, MV Charity.
Break for 2 weeks time.
2 weeks.
Number 10,
Okay, for 2 weeks time.
Decima.
2 weeks. All at 2 weeks.
Number 11, Mr. Nagaraj S. Jain. Number
Same.
11.
2 weeks.
Number 12, Mr. Abhijit S.
Translation is
Your Honor,
2 weeks. Same.
1
order.
week time. My lords, 1 week time may be given, Your Honor.
Apply the translation of Annexure B within 2
Yes,
weeks.
yes, one week time is enough. I will
2 weeks. 2
submit
weeks.
it up. Yes.
Number 13, Mr. S.Y. Shivalli.
Same translation.
3 weeks, that's my lord.
2 weeks.
3 weeks time, my lord. 3 weeks time. my
3
lord.
weeks. 3 weeks. So we are granting 3 weeks uniformly to all. You can remove earlier, all 3, so that easier for you all.
Providers, number 14, Mr. Sachin B.S.
For the appellant, 2 weeks time may be granted to do the needful, my lords. To do the needful, 2 weeks time may be
This
granted.
is also office.
Yes.
How many? 2 weeks?
2 weeks, my lords.
2 weeks.
That's all.
Number 15, Mr. Somchakraya R.P.
Same 2 weeks.
Number 16, Shailesh S.
My lord, I appear for the petitioner, my lord.
Notice is awaited.
Notice is awaited. Some date may be given, my lord.
Given. It will be given.
My lord, in this matter, they have challenged the license given to the respondent number 5.
Yes.
It's going to be expired on 31/3/2024.
31.
It is going to be infructuous. The certificate for operation is going to expire on 31/3, please.
I do not know about the.
So we have filed the report, please, madam. The report is filed on 1st September 2021 itself.
No, if the industry
You are
is
for the
going to.
BBMP,
I am for the pollution control board.
pollution control.
Pollution. Control.
Beyond. Third April.
Third day.
Number 17,
My lord, I appear for accused number 2. My lord, in these appeals and contempt, your lordship's order is impugned. Your lordship being a single judge has passed an order. Those are subject matters in this appeal and contempt.
In appeal also.
All 3 appeals, my lord.
Yeah, there are. So, before some other.
Both contempt. contempt 254, contempt 252 of 2022 with writ appeal number 204 of 2022. Indicate Honorable Mr. Justice Krishna Dixit, bracket over is a member. So both will go to
Please, my lord.
another bench.
Grateful, oblige.
So number 18,
Amendment in the original writ petition has been carried out in the cast title, but in the judgment, this amendment has not been shown. I have filed an application for rectification of the judgment cast title. I require 2 weeks' time, but in the meanwhile, I am seeking for an interim order of stay.
Interim order.
This land has been ordered to be forfeited to the government. Therefore, I am before this honorable court. Kindly see the application which I have filed for dispensation of the production of the corrected copy of the judgment. The copy of the amended writ petition is produced. At page 4 of the application. All the necessary amendments have been carried out in the cast title of the writ petition itself.
So neither you are in,
My lord,
nor
both
you are
in
in cultivating.
the
You are
DC and,
cultivating.
sorry, my lord, both the DC and the appellate authority has gone against the appellant herein. Therefore, the order of interim stay would not arise because if we look into the learned
Is
single
right.
judge's order,
You want us to take up the hearing, then we can take it. Of the appeal itself. What do you?
I am entitled for the stay order because there was interim order during the pendence of the appeal as well as before the this
my
learned
lord,
single
notice
judge.
has to go to the
And we were-
contesting respondents also.
We were cultivating this land prior to the act came into force and we made an application. Without noticing that our name was appearing in the revenue records, the deputy commissioner has passed an order to forfeit 2 of the lands. The appellate tribunal allowed the appeal in part.
The finding, possession is always a finding of fact.
This, it is in my possession.
My lord,
And the categorically learned just said that there is no evidence that you were in possession,
at para 8, please.
nor in cultivation. Both.
And notice also hasn't gone to the contesting respondents. So they would have to have a say in the matter also.
Then 2 weeks time may be granted. I will file the corrected copy of the judgment and I will make the submission on the merits of this writ appeal.
For what purpose?
For production of the corrected copy of the judgment of the learned single judge,
Corrected.
which contains the names of all the persons.
1st of April,
I'll take notice, my lord, in the meantime,
notice to the.
for respondent 1 to 4 and 6.
Learned
AG,
additional education. Additional
Additional
government.
Government Act.
Government. Is so and so. Peta,
Shweta Krishnappa, my lord.
is full.
Shweta Krishnappa.
Krishnappa. Accepts the notice.
Respondent 1 to 4 and 6, my lord.
On behalf of respondent 1 to 4 and this 1 to 6.
Much obliged.
so number 19, Mr. Venkatesh C.
My lord, I plead for the complaints counsel in a contempt petition and contesting response in the writ appeal. My lord, the direction issued by this honorable court, my lord, to appoint the complainant to the post of assistant professor within 3 months. And the same has not been complied, my lord, therefore the contempt petition has been filed.
Lord, I appear for a
The
appellant, my lord.
university has questioned that order, therefore both the matters have been connected.
So writ appeal is pending.
It is connected.
Connected
with
along with
lordship.
this, my lord.
It is there. Raj. Connect.
My lord, one submission, my lord. During the pendency of this proceedings, my lord, the UEC, which is which was a earlier Constituent College of Bangalore University, has become, my lord, autonomous college. By itself, my lord, it has been made as a university itself on the model of IITs. So now, my lord, that's why, my lord, I have made an application for implementing UEC also as a part, because if tomorrow, if my writ appeal has to be dismissed, then they have to implement it. The notice may kindly be ordered, my lord.
filed?
Yes, my lord, IA two, my lord, is filed for including the UEC as a party.
In the writ appeal.
Yes.
Writ appeal.
I think my learned friend appears for UVC also.
But my lord.
ಅವರೇ ತಗೊಂಡು he can come and record as an appellant.
There is one more advocate is there.
This is
my
a
lord. Because I am
counsel on
appearing for
record.
Bangalore University in this.
You appear for that university in many
Yes,
other.
therefore he
matters.
can- I know.
He can come as appellant and he can argue the matter.
Brackets for the respective parties. In this interim application, what is paid is to complete as is number 5. The University of Vishweswara College of Engineering. The basis for seeking implement is that during the pendency of the writ appeal, state government issued notification constituting the which is got to be implemented. State University Bengal, which was a constituent college of the appellant Bengal as an autonomous university since the University of Vishweswara College of Engineering has become a university, in order to formalize its implement, its addition in the course title as respondent is necessary. The present application is granted. Said university is permitted to be joined as respondent 5. Post title shall be accordingly annexed.
Next week, my lord. My learned friend appears for UVC also.
So and so appears for the newly added respondent 5.
Next week, my lord, because this 22 order of 2022.
Second.
I'll take
Second
notice
April.
for
Second
respondent.
April.
Second April.
I'll take notice for respondent 2 to 4, my lord.
Notice to the respondents to returnable on respondent 2. Returnable on 2nd
To 4.
April. Learn and
Lord, there is one more
additional
IA.
government advocate Ms. Shweta.
There's one more IA, my lord.
Yes.
Vice Chancellor was made a party in the. One more IA I filed for impleading because office has raised objection. Because in writ petition, Vice Chancellor also was made a party in the writ petition. I did not make back because registrar is represented, I filed an appeal. But since the office has raised objection, my lord, I had to formally file a IA for impleading the Vice Chancellor also. That may, my lord, that may not be necessary, my lord. Yes.
There is a division bench judgment. It is only the registrar who
Yes, yes.
represents the university.
Yes.
Justice Ramajoy says.
Because the office has raised an objection. That's why, yes.
Seal number 20. T.N. Gautam Raghunath.
I'm appearing for the petitioner. Matter, my lord, pertains to the illegal payments, sheds, my lord, put up on the pavements. Where, my lord, the cattle are tied. And all the garbage, my lord, is dumped into the.
The office objection says
Lord,
the names do not tally with those mentioned in the court.
It's my,
You have to.
please, I need to, I will rectify it, my lord, so there is a wrong description. This was mentioning of the name in the wakalat. Lord, in fact, in the last occasion, the learned council appearing for BBMP sought to file the complaints report. However, my learned friend proceeded to file this application. You want to implead the police commissioner of Bangalore.
The reason being, my lord, they expressed, my lord, their inability without the support of, my lord, the police, that despite they taking several action, my lord, on several occasions, they say, my lord, it requires a continuous vigilance.
It is clear, my lord,
Therefore, my lord, I was constrained to file this application.
I will place before this honorable court on record my statement as well.
or impediment of the commissioner?
I don't know, either unnecessarily is increasing the scope of this petition. My lord,
Just oral.
My lord, it is at their instance, my lord, I was
Application.
constrained to file this application.
IA number 1 of
24, my lord.
24.
My lord, may I make one submission? My lord, every time the jurisdictional police goes and clears the encroachment, my lord, the next morning, my lord, the encroachment is there.
So something more to be done. Something more to be done. Suppose if
My lord, criminal cases, I wouldn't know. I'll have to take information from the police.
I just,
By filing the interim application number, above interim application, it is to permit the Commissioner of Police, Bengaluru City, as is 9. To be implemented as 9. Having regard to the subject matter of the this petition and what is stated in the supporting affidavit to this interim application, the Commissioner of Police cannot be said to be not a necessary part. Therefore, prayer is granted, the Commissioner of Police, Bengaluru City shall be added as number 9.
please,
The post title shall be amended in progress.
my lord, may I request for any date to be fixed?
After 2 weeks.
It's a,
My lord, I take notice for respondent number 9.
One at the additional government of accepts notice on behalf of the newly added respondent.
Obliged.
kindly request for a date, my lord. Every
After
day we
2
are facing,
After 2 weeks, 15th April.
please. Great,
give copy.
please. Great.
Number 21. Prashant Rao, party in person.
The writ petition, my lord, was converted into a public interest litigation.
They were verified to seek necessary.
I'm sorry, my lord.
What you want to do? There is no space in the court precincts.
My lord, on the last occasion, my lords had directed that vehicles that had been
Abandoned, my lord.
abandoned, my lord, some time should be given to them, and thereafter, my lord, they would be taken to the Malasandra yard. And thereafter, my lord, permission would be taken from the concerned magistrate, and then, my lord, notice would be issued, and then the vehicles would be sold.
But you remove the vehicles first so that the lawyers' vehicles can come and they can be parked there.
My lord, could I
It is
just?
completely, it is full of vehicles.
My lord,
Remove those vehicles. To whichever place you want to take, you take them.
very well,
Whatever process you want to do, do it.
very well.
But why the vehicle should be parked in the court premises indefinitely, blocking lawyers' vehicles? The lawyers cannot make use of those vehicles at all.
My lord, even on the streets, they are facing the same problem. My
So to
lord, my
chalk
lord
out a
may
plan
grant.
for,
My lord?
to chalk out a plan to dispose of.
Very well.
So come with the case proposals.
Very well.
This was the direction also in the earlier.
Your Lordship, I have a humble prayer. I have I-8-1 of 2023 for appointment of the court commissioner, Your Lordship, because this particular main road is flooded with the encroachment on both sides, Your Lordship.
Let us see, let them come forward first.
Your Lordship.
No, I don't.
At the request of learned additional government advocate, Ms. Neela Prasad, stand over to 15th of April. That was the next date. Instructions which may be taken to be translated in form of affidavit. To be placed before the court.
My lord, copy which the petitioner, the party in person, my lord, has filed may kindly be.
You want copy of the petition? Share copy of the petition.
We'll follow, Your Lordship.
My lord, I'm sorry, I'm seeking for a clarification. My lord, wants us to give a response as to the phase-wise removal of the vehicles.
So only simple. Don't write that.
Like-
Request of learned, stand over to 15th. April. So we'll say at least to enable you to take instruction. To enable her to take instruction.
Number 22, Mr. Ajit Kalyan.
The complaint complied with the directions.
Directions have been complied with.
Learned advocate for the accused stated that the directions, the order of learned is brought under the contempt jurisdiction are complied. The victim of complaint is confirmed by learned advocate complaint. Paragraph. In that view, the proceedings are closed. Contempt application is disposed.
At 23, Mr. Sumant L. Bharadwaj.
Lord, in this matter, we have filed a review petition in RP 416 of 23.
As this is the submission which they are making time again, my lords. The cause of exorcism is involved. This honorable court directed them to grant a particular land on the submission made by the government advocate. But as the operating portion of the order is
Review file.
That's not posted before us.
Not posted.
as well as posted, my lords. The lordship was pleased to order direct them. If alternative land is earmarked, then we will consider. Since they have not come up with the alternative land also, my lords.
Review is pending. Give the number.
Please.
It was stated that the
416 of
review application is filed and the same is pending in respect to the very order.
Before the learned single judge.
Made subject matter of the present contempt application. In that view to be listed after the. In that view, this court requests the learned single judge before whom the review was posted. To dispose of the same experience.
Yes. I have online status report of the review.
Paragraph. Since the review is pending and shall be dealt with by learned single judge on merit. Presently there is no point to.
Lords, I have online status report of the review petition, my lords.
Presently
In
the
that case also they undertook to.
These contempt petitions are not continued and they are recalling disposal, reserving liberty to the complainant to revive the same in case of necessity.
Obliged.
The thing is, my lords, the cause of exorcism is involved.
We are permitting to revive this very. Yes, next.
Sir. Number 57.
The appellant herein is a member of respondent number 4, primary society of All Women's Cooperative Society, respondent number 4. Respondent number 3 is a federal society, that is DCC Bank, Mandya. The appellant was elected as a delegate to participate in the election of respondent number 3. She also got elected, that is, as a representative of respondent number 4 society. I got elected as a director on the board of directors of respondent number 3. The rival candidate questioned the election on the ground that my membership in respondent number 4 society is under dispute.
Under dispute.
Under dispute. Section 7, the facts with regard to that are, I am a member of respondent number 4 society from 2006 onwards. In the meanwhile, as there were no qualified candidate to be the secretary of respondent number 4, the petitioner was appointed, that is appellant was appointed as the secretary. I functioned as a secretary for about 2.5 years, almost 3 years, and resigned from the post as and when the other person became available.
When you resigned?
Please, madam. I resigned on 18/3/2019.
When the election took place?
Election to respondent number 3 took place on 8/9/2019.
After you resigned?
After I resigned, meanwhile, there was another development, my lord. Meanwhile, respondent number 4 co-opted me as a director in a vacant post on 5/4/2019.
After you resigned?
After I resigned, I was co-opted as a director. Thereafter, I was appointed as delegate. Now, my lord, it is challenged on the ground.
Co-option was challenged.
They have not challenged the co-option, but they say you cannot be a member at all. Our defense was, with regard to my membership of respondent number 4 society, it is not something which can be challenged in an election dispute pertaining to respondent number 3. Kindly see section 17, my lord. What ultimately the learned single judge has held is,
It cannot be subject matter of election dispute at all. Is your version?
With regard to my primary membership of respondent number 4 is not something which can be called in question in an election petition pertaining to federal society.
Whether co-option is an election?
Co-option, of course, there is a specific provision saying, so if it is a vacancy which is caused after half the term, that is 2.5 years, it is not, it is to be nominated or co-opted is the provision made.
No, we are asking you because of election jurisprudence.
Of course, it's not an election in the regular sense, as election is not conducted, but I am an elected director. I occupy the place vacated by an elected director, and I am treated for all practical purpose, including contesting for the office bearer, etc., as an elected director.
Election is not defined there?
Election in that sense, it's not defined.
Your co-option was before election.
Before election, before respondent number 4 election.
So you are saying that by virtue of co-option, you derived the eligibility.
Eligibility.
You amend in it, we can-
Without the challenge to that, challenge of my appointment as delegate by itself would not get the relief, would be my submission.
Anybody can become a delegate, whether elected or co-opted,
Yes,
which is the section.
a direct, that is section 21. Subsection 2. Twenty-one, 2A. 21(1) provides that every cooperative society which is a member in another society has 1 vote. 2, notwithstanding anything contained in subsection 1, the board of a cooperative society, which is a member of another cooperative society, may appoint one of its members of the board to vote on its behalf in the affairs of the other cooperative society. Delegate is also defined. 2E1A. Delegate remand, etc. They proceed on the basis that my membership under section 17 was not a proper membership. Therefore, you become ineligible is how they have proceeded with regard to
So not election petition as such.
in an election petition, the authority holds that under section 17, you are disqualified to be a member of the society. Therefore, in turn, your delegation is invalid. Therefore, in turn, election should go.
Suppose if co-option is held to be bad.
Please, ma'am.
You cease to be delegate. That legal position you admit.
That can be this thing, but the challenge to that has to be an independent this thing where respondent number 3 will not have anything to do, that federal society, etc. My delegate, I becoming a delegation is independent of this thing.
That is only consequential.
Of course, again, delegation as such, if it is contested, it is also by election.
No, not like that. The delegation is on an inarticulate premise that your co-option is valid.
I am a director.
Correct.
Yes.
If co-option is voided, then the superstructure also falls to the ground.
That could be the situation, but the challenge to that, my respectful submission may have to be independently made and not in this election petition.
Which section? Challenges under which section?
Now, the reasons assigned are with reference to section 17, but the election petition is under section 70. Like any other general dispute, they are not framed separate rules and all for election petition.
Sir. What happened in 2015, Mr. Council? What happened in 2015? You ceased to be a member?
That is how
That is how it is.
it proceeds, my lord. Reasoning proceeds.
That
For
appears to
that,
be the crux of the matter.
please, my lord.
On that day, you ceased to
Yes,
become
my lord. For that, my lord, your lordship may kindly peruse section 7.
And your submission about co-option is not figuring anywhere in the order.
Yes, my lord. My directorship of that is my first ground of attack is my directorship and my election as delegate in from respondent number 4 is not questioned at all. Unless, as your lordship said, your primary membership is supports me.
He became the employee of the society.
Yes, I became employee of the society and I resigned. That's what I gave the factual aspect.
So that was before election.
Before election.
So therefore you were never eligible on the date of election.
Your lordship may kindly see section 17, my lord, for
Let
a
us-
moment.
Let us. 17. What does it-
17, my lord.
Yes.
No person shall be eligible for admission as a member of a cooperative society if he applied, adjudicated or sentenced, carries on business of the same kind, is already a member of cooperative society, is not eligible for membership. If he is a paid employee of the society or its financing bank or its union.
Or its federal society.
Yes, my lord. It is at the stage of admission, this comes into picture. In 2006, when I was admitted as member, none of these disqualifications applied. Now, your lordship may kindly see subsection 2. If a member, that is existing member, becomes subject to any of the disqualifications specified in subsection And but your lordship may kindly see the word is in F. They challenged it on the ground that you ceased to be a member. Primary member. You ceased to be a primary member. Therefore, you could not have been made as delegate. That there they may not be correct for the reason. Kindly see the disqualification individually are provided under section 29C. I don't come under any one of those categories. No, they don't dispute. No, they say you should not, could not have been. Kindly see section 29C, my lord, individual disqualifications. I will not come under any one of those. 29 capital C, my lord. No person shall be eligible for being elected or appointed or continued as a member of the board of any cooperative society if he is in default to that society, if he is interested directly or indirectly in a contract, if he carries on a business of the kind carried on by the society, if he is employed as a legal practitioner on behalf of that society, he is a paid employee other than chief executive of such cooperative society or its financing bank. I was a chief executive officer. I was appointed as secretary. This E.
Secretary, chief executive officer?
Yes, yes.
There is such a section?
It's a definition. He is a near relation of a paid employee of such cooperative society. G. He was paid employee of a cooperative society and was dismissed, removed, or compulsorily retired. I don't come under that also.
So, two contentions you are urging.
Please.
One is, I was not an employee of the society at all, because as on the date the co-option happened in April 2019, I ceased it to be employee, whatever it be. Number two, assuming that I am an employee, I answer the description of chief executive of the society, and therefore under section 29CE, protection is afforded.
That disqualification will not apply to me. The chief executive, your lordships get the definition, my lord.
What is difference between 29C1 and 17?
17 is not contemplated as an election dispute at all. Section 17 is a separate proceeding. As and when someone comes to know that I am not a person qualified to be a member, I have become a member, they may remove me. Section 29C is for the purpose of election. It says.
Where is a co-option provision?
Please, ma'am.
29.
That is section 29 capital E, ma'am. 29 capital E, your lordship may kindly see. Any vacancy in the office of members of the board of a cooperative society by reason of death, resignation, removal, or otherwise shall be filled up in such manner as may be specified in the bylaw of such society. Provided cooperative election authority shall conduct the election to fill up any vacancy in the office of director of the board if the remaining term of office of the board is more than half its original term, if it is prior to 2.5 years. Provided further that board may fill up the casual vacancy of the board by nomination out of the same class of members in respect of which casual vacancy has arisen, that may not apply. There is another provision, Lord.
What is meant by second proviso?
Second provision is, my lord, if there is any delay in holding the election, till then, till the election is held for such vacancy. If a vacancy has arisen within the period of 2.5 years, election authority has not held the election for any reason, then a temporary filling up can be done till the election is held.
How that is done?
By the board.
No. Whom? How board is choosing? See the wording, terminology. Out of the same class of members.
Yes, same class of members. Here there is no dispute. Only primary societies that are member are milk producer societies at the village level. There is of course, I'm not sure whether that book contains the second proviso.
We have that.
Yes, it is.
There are 3 provisions.
Three provisions. Third one I'm saying, that is, if vacancy has arisen after 2.5 years, it is the board which will fill it up by co-option or nomination, whatever may be the nomenclature.
The registrar shall fill up through nomination.
ಅದಲ್ಲದೆ ಇನ್ನೊಂದು provision ಇದೆ, there is a mistake. You print ಮಾಡೋದು. 2.5 years, it would be filled up by holding election. After 2.5 years, it will be society which would fill up.
Another amendment has happened.
No, that was the original provision. This the second provision which up to election, that was added by an amendment. In adding that, they have left out the original provision. This book contains. In inserting the new provision, somehow they have given up that second one.
Same proviso we have read now.
Not up to election. Your Lordship may kindly see second provision.
Second proviso. The remaining term of the office is, sorry.
Then election authority will not come into picture. It is the board which will make the co-option.
But so far as that remaining period, etc., no issue.
No controversy, no controversy.
So same class.
Same class. Same class of.
Same class, because they don't have any other member. It is only primary milk producers, village level societies which are members.
Were you a member? Were you a member?
Yes, my lord.
When, how? After you were appointed.
Yes, my lord.
you
That's why I
ceased
said,
to be a member.
after resignation, I did not again become member. According to me, my membership as done in 2006 continued.
That amounts to virtually rendering
17-2.
What years?
For that, my contention is, my lord, my society or any member of my society were to question it, I would have become a member. My society treated me as a member, not only member, it said I'm eligible even for co-option as director. Therefore, it became a disputed question which may have to be decided under 17(3) independently.
Society cannot do something which a legislative house said contrary. By your suggestion of membership is by operation of law. And if any dispute arises prima facie, which we cannot decide based upon the material on record, then it travels to 17(3).
17(3).
But if the facts emerging from the papers, coupled with your arguments, if we come to a conclusion that there is no dispute as to you being not a member, then there is no question. Not every dispute. It is not that somebody says on the street, you are a member. Another person on the street says, you are not. It will not travel to 3. There are such English judgments. Even to travel in the law line, there are minimum facts are necessary. If those facts are available on record, can be ascertained from the record, then it will not travel to that level at all.
Of course, my lord, if I were to come to the court under writ jurisdiction, something could have been said, we don't want to exercise jurisdiction, etc. Otherwise, my first contention itself is the person who challenges my membership has nothing to do with my primary society.
No, that's another contention. That is locus and locum. Now the first substantive argument, unless you show a provision.
Yes, my lord.
One second.
I stop at that.
One second. There are certain legislations. Immediately, I may not be able to recall the title. There are certain legislations which say you cease to be a member as long as you are a secretary, this, that, etc. And no sooner you resign from that post, your membership is revived.
Of course.
Once you cease to be, then to revive as phoenix, law has to come in your aid.
For that, my lord, my only defense is section 29C E 2E.
Therefore, we ask the difference between 17(2) and 29C E. We ask, that is the reason I asked, why, what is the difference between these two?
29C is the eligibility to contest the election. No person shall be eligible for being elected, appointed, or continued as a member of the board of any cooperative society if he is paid employee other than chief executive of such cooperative society or its financing bank. And one other thing, my lord, of course,
What is meant by, you will not fit into elected. Then appointed,
I fit into shall not eligible for being elected. Now I am contesting election of respondent number 3.
no. That you can do only if you happen to be the member in the eye of law of a respondent number 3 society, 4 society, 4 society. That itself there a dispute.
Dispute raised by altogether a third party.
We will come to that one. That's on locus now. We are on the substantive provision of law.
Substantive provision. Of course, the only defense that I can put up is, as regards chief executive, there is an exemption. I was a chief executive. I gave up that post and nobody disputed in my society about my membership. And actually, society is actively supporting me, saying I'm a member, I'm a director, and I have been elected as delegate.
No, this is member of the board.
Member of the board.
29C1.
Please.
Member of the board. Status is different.
Please, ma'am.
They're the member of the society. Kindly see, there is a presumption that legislature does not duplicate the law. The section 17(2), which you have mentioned now.
It is regarding primary membership.
Let us face that section now.
Please. If a member becomes subject to any of the disqualifications specified in subsection 1, he shall be deemed to be a member. That's primary membership. No dispute about it. Only thing that, according to me, in my favor is my society, any of the members of my society, nobody have disputed my being continued as a member. And in fact, actually, I was appointed as co-opted as a director. And that is not questioned by anybody.
No decision of any high court on similar line.
No, not. Whether it can become subject matter of the present election petition itself is something to be.
Your submission appears prima facie, subject to other side saying something else. Your submission runs counter to the legal effect of a fact situation contemplated under subsection 17(2). Yep. That runs counter to that one.
That
the intent of the legislature is by X factor, Y result follows. Society cannot say, no, whether Y factor follows or not, society will decide. That will be that amounts to placing the society in a super legislative status. Legislature says, by operation of X fact matrix will have this effect.
Of course, the only other explanation that I can give is this, my lord.
Whether co-option
Per se will make you a member.
Not only co-option, my lord.
No, co-option per se will not.
Yes, my lord.
Will not bring you the status.
I would say.
You have to say that the co-option.
That is the only thing that.
That is the only thing you are saying.
Right. The very fact that I am treated as a member and I am made as a.
Unless you say that, you can't.
I am made as a director.
Advance in your argument.
Please,
you have to say that your co-option was equivalent to your membership.
My membership.
Now that proposition doesn't appear to be correct.
That will not be correct only for the reason that procedure is not followed.
Is filled amongst the class of members, then the other co-option, etc. would arise. One is the substratum of the other. Therefore, as Honorable Chief Justice said, even I feel like that. unless you convince us to the contrary. Kindly see the phraseology of section seven.
Class of members.
Class of members.
Please,
It is from that
the society, there is no dispute, or it is not the subject matter that I am not entitled to be a member of respondent number 3 if I apply today.
The court is not examining whether your co-option is correct or not.
correct.
We are only examining whether you are a member.
Member as
And
a
whether you are able to draw the eligibility by the.
That's what I'm putting it, my lord. It is not the case of anybody that I am not eligible to be a member of respondent number 4. I am eligible to be a member of respondent number 4. I was a member. For a moment, for argument's sake, I accept the fact that I ceased to be a member on my employment. Thereafter, there is no difficulty for me becoming a member. Only thing that can be said against me is, for membership, you should have filed application, you should have given fees, etc. But that is not something which can be, which is not something to say. If all the facts show that it has been accepted like that, then that is not a defect on which I could be sent out.
What are the modes of becoming member?
A simple application with prescribed fee of 100 rupees or 200 rupees.
That has not happened after
That
you
has not
resigned.
happened after resignation. But it has also not happened that my membership and my share amount was returned after I became a employee.
You showed the provision about the co-option. Where is that?
The 29 capital E.
29.
Members of the board. Co-option is not a legally recognized mode of becoming a member.
Exactly. That's it.
Yes, it's only director.
Next level it is.
But that presupposes that I'm eligible to be a director there, which is membership.
The term member is also defined.
Definition is also there.
Member is defined. Member is defined. Right.
Admitted as member.
Yep. Only 2 modes.
The second argument is no locus standi.
No locus standi to examine these things in an election petition pertaining to respondent number 3.
Are they members of the society? Those
They
who
are,
are
they are
challenged.
different society. In that constituency.
Different society, but in the federal society, they are a feeding cadre. They are feeders.
The society which my learned friend represents is also a member.
You were contesting candidates.
Oh.
Right to vote. Right to vote. Yeah.
Right to vote is.
So therefore,
they will be.
right to challenge the election.
Challenge the 82 Supreme Court.
Right to vote by a society. All of us are only persons authorized to vote on behalf of the society.
You are not only postman of the society, you are a delegate of the society.
A delegate of the society to contest vote, authorized to vote. But it is the member is, for respondent number 3, member is the society.
Let us see what they say. Any other argument you have?
Please.
I appear for the election petitioner, who is respondent number 5 in this.
Election commission.
Election petitioner.
Petitioner.
I filed the election petition. there were two election petitioners. I was a contesting candidate, so I filed the election petition. And the society which had sponsored me as a delegate for this election was also an election petition.
Another society.
My society. Yeah.
Other than, that is respondent number?
I'm respondent 5. Respondent 6 is my society. Of which I was a delegate at the election where she got elected.
That gives locus.
Yeah. Sir, at the outset, I should go down to the so pertinent questions already put. That is the crux of the matter. Can there be a
The Honorable Chief Justice said, till then my mind did not open. Whether by co-option do you become a member? Perhaps no decision.
If I may say so, with respect, that is
If
all.
that way to be answered, perhaps.
There is something more than that. Sir, why is a paid secretary disqualified to be a member? Why is a paid secretary ceases to be a member?
It's a policy of the state.
No, sir. This is the philosophy of a cooperative movement. That it should be a voluntary cooperative movement.
Once he is an employee, that will be lost.
Once she became an employee, she ceases to be a member. The word used is cessation of membership. It is not suspension of membership.
And no revival provision.
No revival. If I may say so with respect, I should salute the learned single judge. On first principles, he has written such a wonderful judgment. Considering all the
Co-option is in the board.
co-option is only of a director. That also I'll point out.
Therefore, co-option is not as a member.
No, never, never.
You can't say by backdoor reasoning that once you are co-opted,
Sir, may I just
you become a member.
just two
That
provisions.
is independent of the fact that co-option is.
I go down.
even
I
otherwise
go
of a
down to
board,
that.
Not of a member of the society.
Section 2F defines a
So that
member.
is what we're trying to distinguish.
We have seen that.
Only two modes of becoming a member.
The other mode is not there.
One is the founder member, another is a member admitted on an application. How
100
is
rupees.
it to be done? Section 60.
One is by application, other by
Founder member.
He is a founder of the society.
founder.
When they promote a society, sir, I think learned Chief Justice would have had greater exposure to the cooperative movement than all of us here. Because the milk producers unions, Gujarat is the founder of that concept. So therefore, I am sure there would have been much more serious contests of the cooperative elections. So this is how I remember. Now, for the first time before this honorable court in a writ appeal, it is canvassed, I am a co-opted member. Was this the case before the
Learned single judge.
Election.
authority.
election tribunal? Sir, kindly turn to section, page 200. Just look at the pleadings.
You say your first point is, the point now canvassed was never figured at
Sir,
the
it is a
initial levels.
fantastic story. Now it is being invented.
Next point. Can you go to the next point?
Yeah, no, I wanted to show from the pleadings.
We have read also. We have read the pleadings.
Election petition.
We have read the entire proceedings are placed on record.
Sir,
Can we go to the next point?
yes. This was never the case before the election. On the contrary, I have given very copiously in my election petition.
Understood.
That she is not a member and therefore she is not elected and therefore sponsoring her would be against the statute. She cannot represent the society.
Next
and the
point.
delegate.
Next point. We have understood that now.
Sir, only one, I'm sorry, I'm sure the court will have read it. In her evidence before the election tribunal, kindly permit me to show what she claimed. This fantastic story of co-option.
whether it was there. Kindly permit me to show at page 200. Evidence. Sir, page 212, annexure E1. The translation is at page 214.
Paragraph?
Paragraph 2, sir, 2.1. 2, it is 2.
2.2.
No, 2, para 2. I herein solemnly affirm that for the federation of the second respondent, the third respondent society is a member society. And I am presently elected director of the third respondent society as per the Cooperative Society Act and the rules on the basis of the elections conducted by the third respondent society. So it is, she claimed that I am an elected member. Where does it figure, sir? This fantastic story, I am co-opted. Where does it figure?
Next point.
And in her pleading, she never disputed the fact that she is not a member.
No, she has taken up a contention already that she is a member of the federation. There, in para 2, I herein solemnly affirm that the federation of second respondent, the third respondent society is a member society, and I am presently elected director of so and so. Your whole case is she is not a member of the society.
Yes, that she has never.
Ceases to be.
She never disputed.
Understood. We have understood.
I have said in paras 15, 16, and 17, saying that she is not a member, therefore she cannot be a director. And my learned friend put forward another fantastic story that on 5/4/2019.
5/4/2019.
Yes. 5/4/2019, she was co-opted.
Not true.
It has come in evidence that she continued as a secretary.
As on?
As on 24/4/2019.
24/4.
Page 362, annexure.
That is even after.
Yes. No, that's all.
So-called co-option.
Sir, all that is a backdated one. See, this is how a paid employee becomes so powerful in a society. Starts manipulating the cooperative movement, cooperative society itself. The very object of the cooperative movement is frustrated and sabotaged by these paid employees. She's so powerful. She can get anything done.
So your point
That is the strong point of the.
So your point is, as on the date the election took place, she was continuing as the secretary of the society.
Yeah, no, this theory that she resigned.
Will not, all that is not.
It is false.
Yes. Third point.
The third point is, my very respectful submission is, if she is not a member, she can't become a director.
So everything.
So therefore, everything falls. If I may say so with respect, these facts were not in dispute. That's why in her evidence, she claimed that she is elected. Where does it figure? I am from the same class. I am co-opted. Where is this story, sir?
I do not remember Mr. Jaikumar Patil had argued that right to vote, the precondition for right to vote is the membership. You had argued that. There is a one reported judgment. I don't remember. The memory.
This co-option will confer right to vote or not, Mr. Will not be. So that is the cross.
That's what the
crossroad.
What Professor was saying. Will not travel to that.
Section
Will not
20 gives the right to vote. Section 20 gives the right to vote.
That is not necessary. This is this, we are prolonging our thinking, but not
Sorry.
necessary. Not
I'll rest my case with only one provision to be brought to the notice. Now, so much was said about 17.1, YAP and 17.3. They request the court to kindly roll down one more page and come to section 18 capital A.
87.
18 capital A.
18.
Sir, there are two different concepts. One is cessation of membership. Another is cessation of directive. Cessation of membership, kindly mark it. This is membership that is put an end to. A person shall cease to be a member of a cooperative society. In the case of an individual, she is an individual.
Death, resignation. Third will be applicable.
Third.
Disqualification or suggestion.
There ends the matter, sir. Nothing more is needed. By operation of law, she is out of the society.
So the employee becomes this one.
Public.
I would- Something, something about the, something about the pleading is being said, which probably my learned friend did not have the correct information. Kindly see page 198. In his election petition, he is very categorical saying, so and so was appointed, page 198, para 12 and 13. Copy of the resolution in 12A, copy of the resolution dated so and so, appointing respondent number 4 as secretary. D, copy of the resolution dated so and so, adopted by the Board of Management, accepting the resignation of respondent number 4. Para 13. It is submitted that respondent number 3 appears to have illegally co-opted respondent number 4.
As its director, not as.
I'm not saying about, my learned friend made a submission that they are bringing out an imaginary story of co-option, etc. I think that was something which was not necessary for the case and factually wrong.
There is always some hyperbola, parabola at the bar.
Lords, I'm appearing for the society of which the present appellant, my lords, is the co-opted director. Lords, my grievance is only one thing, my lords. This is a federal society, the election of which is called in question under section 70. Federal society consists of only the societies as its members. The election of the federal society takes place on the basis of the delegates of the primary societies to participate in the process of the elections, and thereafterwards the election will take place. But fact remains that the membership, so far as the federal society is concerned, will be only of the members of primary cooperative societies. If any dispute requires to be raised, if your lords were to see the language under section 72C of the Cooperative Societies Act,
Any dispute arising.
any dispute arising, lords will next mark the words in connection with the election. In connection with the election of a president, vice president, or any office bearer or member of the board of the society. But now, the reason why I'm submitting that it's a federal society is, these are all watertight compartments. Primary society is a watertight compartment
no intruder can come and raise a dispute pertaining to the primary society. If your lordships were to see, the language employed under the entire scheme of section 70, there is no scope for any person who is not a member of the concerned primary society to raise a dispute pertaining to any of the affairs pertaining to the primary society. Notice, once we have co-opted, it's an in-house issue. The society co-opts the present appellant. It's an in-house issue. If anybody gets aggrieved by the co-option, it is only the persons who are the members of our society, not a third party. Notice now, once the co-option is done, the delegation is done in terms of section 21. Notice the post-delegation, when participation is done, are the only issues which will be germane for consideration in a dispute pertaining to the election of a federal society. Otherwise, it has got cascading effects. If this is the manner in which it is to be done, every delegation, every co-option of every other primary society will be vulnerable at the hands of every other member of the primary society with which our primary society is not concerned with. Notice, this will be a far-reaching consequence. These are all watertight compartments and it has to be retained that way. Cause under the scheme, because notice, so far as the cause of action or the locus is concerned, it is already fixed under the statute. There cannot be a greater locus to be claimed than what is provided for under the statute itself. So therefore, my respectful submission only to the extent of the jurisdiction which could be exercised in terms of section 72C, so far as the election of the federal society is concerned, is post-delegation disputes. That is, after the delegation, when I file the nomination form, whether my nomination could have been accepted, so on and so forth, will be the nature of contentions which could be considered. But pre-delegation of whatever has happened, transpired with the primary society is not germane for consideration under section 72C. Otherwise, it will be impinging upon a jurisdiction which otherwise is exercisable in terms of section 17(3) of the Act, which is an independent power to be exercised. That is essentially between that society, that is our society, fourth respondent society. So therefore, it's an exercise to say that our delegation is not valid in a dispute raised pertaining to the election of a federal society would not be correct. There is a complete insulation so far as the process which I have undertaken, except in the manner known to section 70 or section 17(3) of the Act. No third person can come and challenge it. So therefore, my respectful submission is that dispute of the kind itself could not have been entertained. It's essentially the point which we raised even before learned single judge. That's grateful for the hearing.
I was not a third person. That's third person at all. This one were 5.
Lordships.
Who raised a dispute.
Yes.
Was an outsider. In terms of the election.
In terms of my society, in terms of the fourth respondent society, he is a stranger.
Well, he was also in the fray.
He is in the fray in the federal society. In so far as my society, my primary society is concerned, he is a stranger.
Your status of as a primary is very much material.
My status, the status as a primary society member.
You can't dissociate yourself from the entire process of election.
The question of dissociating, that is the reason why I said, there is a dichotomy.
Insulation. You accepting your contention, of course, we have to treat it is another thing.
Yes.
Prima facie, accepting your contention would create an illegal, we do not know illegal, illegal or religious contention, an illegal situation which the law does not favor. We have to interpret the law as the instrument having some nexus with the people in the trade.
True.
If we interpret it so technically, then the link between the living law, it should be living law of the people in the trade.
Yes.
Now, if that is accepted.
Now, if that were to be the situation, I wanted to go a step beyond and say this. Your lordships may recollect, that the coordinate bench with your lordships combination has taken the view that preparation of an electoral roll is also an inherent process of the election. That is the view which your lordships have already taken, qua the cooperative society. That's that judgment. The reason why I am submitting this is there is no challenge to the electoral roll. Electoral roll will disclose that my society is the member and so is the delegate. If your lordships were to see, if there was no challenge to the delegation at the first instance, And he being incorporated, she being incorporated as a delegatee.
I think this question is answered in election to member of Rajya Sabha.
Yes.
AK Subbaiah versus Jet Malani.
True. Lords,
The identical question was raised.
yes.
If Mr. Jet Malani's name figured in the electoral roll, unless you get him downloaded from that
Electoral rolls.
you cannot maintain an election petition was the contention.
Yes, that was
It's
not
a reported
Yes,
judgment,
Lords.
where they said they repelled this contention.
I understand, my lords, but so far as the cooperative society jurisprudence is concerned, Sant Jagadguru's case, that one Supreme Court judgment which dealt with the parimateria provisions of the Maharashtra Act, which your lordships have referred to in the coordinate bench judgment, my lords.
They have referred to that
Yes.
judgment also.
Where your lordships have very specifically said that it forms a process, it forms an integral process of the election. And therefore, lords, that is also open for challenge. That is not something which has been challenged. Lords, the reason why I am submitting this is that if beyond the society, lords, I can understand in a federal structure, a person who is a delegatee is entitled to represent that society. Lords, if your lordships make my apologies, lords, kindly have a look at section 21. To what extent the delegation goes?
21.
Section 21. Subsection 2, my lords. This is the only extent to which the delegation is made. Every member, my lords, I'll read section 21(2), my lords. Notwithstanding anything contained in subsection 1, the board of a cooperative society, which is a member of another cooperative society, may appoint one of the members of the board to vote on its behalf in the affairs of the other society. This is the
Member of a cooperative society.
Lords, yes. Lords, there, the board of a cooperative society, which is a member of another cooperative society, may appoint one of the members of the board to vote on its behalf in the affairs of the society. That is, this is the limited extent to which the delegation operates. Then the delegation go beyond this. Then lordships may kindly see the proviso. Provided that where a new board is elected to a cooperative society, newly elected board shall send a delegate or nominee to any other cooperative society where it is a member. Then subsection 3, a delegate can be changed.
Whether can there be a delegate who is a non-member?
So the law declared is that he should be a director.
He has to be a director.
He should be a director. Not
Can,
that, of course.
can a non-member be a director?
Lords, once a co-option takes place, because co-option, if it takes place, it should also be from the same class of members where the vacancy has arisen. Under 29E, that is a position of law. Lords. That is something which I can never dispute. Just two sentences I'll just state and conclude. Notes. The reason why I read subsection 2 of section 21 is, notes, in relation to a federal society, if the delegate's rights is restricted to vote on its behalf in the affairs of that society, election, if your lordships were to take election, my lords, who can rise under section 70? Notes, a person who is a delegate, at the most he can file nomination, he can vote. Whether that person who is participating in the election can still claim the status as a delegate for the purpose of raising a dispute under section 70 will also arise, because the reference under section 70 is only a member. But otherwise, it is not permissible that some third party will come and challenge. He should be a member.
The dispute is, section 70 appears to be little broader because it excludes the jurisdiction of civil court.
Yes, it excludes the jurisdiction.
68 or 16 and Dhulabai versus.
Yes,
State.
there is no difficulty, not that it excludes the jurisdiction of the civil court square the disputes that can be considered under section 70. There is absolutely no difficulty about it. But this is a dispute under section 70 of the Act. It's the delegate of a member society, because member has to raise a dispute. If the member doesn't raise a dispute under section 70, my lords, there is no, if your lords were to see under the entire scheme of section 70, there is no reference to the word delegate, who is capable of or who is otherwise entitled to raise a dispute in terms of section 70. And this goes in tandem with what is stipulated in the section 21(2), which says that the delegation is only for the limited purpose of voting and participating in the affairs of the federal society by a member society. That's my submission. Grateful for the hearing. Thank you.
So the writ appeal is dismissed.
Lordships.
Reasons. Yes, Professor. Thank you. Thank you for enlightening me.
Sorry, no, both of them. Each side was very succinct. Right or wrong is different.
In fact, the learned single judge has written on first principle. First class.
Yes.
Yeah, please, last.
This matter, not, I pray for some time, connected appeal.
Appeal is there.
Appeal is there,
Yes.
24.1.
Huh.
I pray for some time because file was misplaced.
Both to be listed together on which date?
Next week. Please.
Next week, 27th March.
Oblige.
Your Lordship. There was a willful disobedience of the order dated 26/7/2023, Your Lordship.
Why the articles are taken?
I'll go through the order, Your Lordship.
Freebies to be distributed.
Freebies.
In that connection, they were seized.
Your-
Simultaneously, my lord, the proceedings under the GST Act were also initiated.
Your Lordship, it has been seized before the code of conduct has been called, Your Lordship. On 25/3/2023, it has been seized and code of conduct has been called on 28, Your Lordship.
So what's
And,
the order?
Order is that, Your Lordship, the para number, page number 21, Your Lordship. Having heard the learned counsel for the parties and having pursued with the petition papers, the court is inclined with the direct conditions release the seized articles in much as the elections are already over and there is no justification for retaining the custody as any longer. It is open to the authorities to take the indemnity bond for the worth of the articles seized and also the photograph, videography of the said articles and their packages so that the same may be made use of in trial of a subject criminal case to take the indemnity bond and to release, Your Lordship.
There is a,
And-
Mr. Niralgi, there is a direction.
There is a direction.
There is
Lord,
direction.
in accordance with that direction, after the receipt of the certificate copy, we issued an intimation at, my lord, R7.
Saying
that in view of this, there is a violation of a GST Act also. GST Act mandatorily contemplates, my lord, bond as well as the bank guarantee for the provisional release of the goods. You please come and furnish both the, my lord, and then we'll release the goods. This is the intimation which we have sent.
Given,
But order does not say that.
My
You
lord,
are a party to the proceedings.
I was not heard, my lord. That's my lord
That
difficult.
makes no sense because you are a party, res judicata operates, whether you are heard or not. We cannot, res judicata does not depend upon you being heard. It depends upon you being a party.
So you,
We are not issued with the notice also, my lord. That's
You should have made application for recall of the order.
we'll seek a review of that order, my lord. My lord, may I make one submission? We did not, my lord, refuse to release the goods. We said that there is a proceedings under the CGST Act for violation of, my lord, CGST rules and the law.
We understand.
Accordingly, my lord,
Since there is rightly or wrongly, there is an order.
Please.
Unless that order is vacated, modified, etc., you cannot argue a thing
which is not,
which runs counter to the mandate.
we said that my lord, you execute a bond as per the order of the High Court, as well as the bank guarantee as per the Rule 140 of the, my lord, CGST Act, because there was separate proceedings, my lord. Caesar was done under the CGST Act. We'll release the goods, my lord. He agreed, my lord, initially. Subsequently, my lord, he filed.
Where has he agreed?
your lordship.
My lord,
I have given
R8 at, my lord, page 26 of my counter.
Any written submission was made by him saying that I am agreeable to furnish the
My lord,
guarantee?
we valued the goods at, my lord, 3.36 crores and asked him to furnish the bond and the bank guarantee. He said that, my lord, he said that, no, goods are not valued at 3.36. It is only valued at 46 lakhs 29,487. To that extent, I am ready to execute the bond. That's only
Where
he
is
said.
it?
That is, my lord, R8, in page 26, your lordship.
R8.
Yes,
26.
26, your lordship.
You have agreed to give the bond for 46 lakh 29,487.
On 6/3/2024, once again, they have given one letter stating that now it is worth, we have to give a security of 13 lakhs 36,000. Now newly they are coming, your lordship. There is much threat, your lordship. After this order has been passed.
It's all right. It should be willful
Yes, your lordship.
disobedience. There are two things that weigh with him. Number one, court somehow passed the order without hearing him, although he was on the outside.
Yes, your lordship.
Number one. Number two, you went before them pursuant to their notice and said, the valuation of the goods is not that high. It is much less. And you have quantified 46 lakh 29,487. You give a bank guarantee to that effect. The rest of the things will follow.
Well, bank guarantee is only to the extent of 13 lakhs 36,000.
That's all.
That's all.
They're agreeable for that also.
Yes, your lordship, but your lordship, I am ready, your lordship, but your lordship.
If you are ready, go on arguing will not yield any milk to your client.
Your lordship.
Instead, go furnish that 13 lakh, whichever you said now, even that amount is reduced now. Though you said 46 lakh, now they have issued one more notice to you, almost reducing it to 3.5 times, 3.25 times. Therefore, furnish that.
And your lordship, even when the order has been passed, it has been taken by one of the advocate, your lordship. The page number 15, kindly peruse, your lordship. The language of the GST commissioner was very worst, your lordship. They have stated that this type of orders, it has been.
In any case, it's a conditional order.
Indemnity bond.
Indemnity bond.
Yes, I am ready.
So what we are saying is not something outside the purview of the direction.
Because law provides for bank guarantee.
Law, my lord, it shall.
Why I have
be
came
released
here?
on,
Because
my
of his
lord.
language, your lordship. He has told this type of orders have been found in my dustbin.
There
That
no-
is his language, your lordship.
As my brother is right.
Why he must not be apologized before the court, your lordship?
No willful unless you.
We should not much depend upon language nowadays.
Yes, but order
Language in
is,
even
order was there, your lordship.
Understand. Language, even in any constitutional institutions, it is getting bit deteriorated is our observation, subject to exceptions. In any constitutional, we will not deliberate more on that. Leave the language apart. Now, my lord has pointed out, if there is a direction, indemnity bond. Instead of indemnity bond, they are saying, give the bank guarantee because they have support of law.
Your lordship.
Section provides for that.
Yes, for bank guarantee, we have to make a payment before, give the
Yeah,
payment before the bank and we have to get it, your lordship.
How
Your-
to
your
execute
lordship,
indemnity?
I will seek a instructions so
No,
that
no, no.
from my
Nothing.
party,
Nothing.
a very,
my
a short
undertaking-
accommodation may be given to me, your lordship. I will take instructions from my party, very short accommodation may be given to me, your lordship.
No, no, brother, you have argued already. Perfect. This complaint alleges violation of a single judge's order dated
You are the.
26 July 2023. First, para 3 of the said order is texted as under. First, next, learned counsel for the complainant submits that the third respondent being a party nominate to the said order is bound by the direction contained therein, and therefore he is liable to release the goods that were seized before the election process was set in, going by the election code of conduct. First, learned counsel representing the respondent accused vehemently opposes the petition complaint, contending that the release of the goods cannot be by way of taking indemnity bond, since it is very difficult to execute bonds of the kind, and therefore the complainant should give a bank guarantee for the worth of goods. First, he also points out to the court that the order was passed without issuing notice to his client, which we find is true. First, added the provisions of GST Act, which is that section.
Rule 140 of the CGST rules.
Rule 140 of
CGST rules.
CGST rules provide for release of the goods after taking the
Bank guarantee.
Bank guarantee. First, therefore, he submits that there is no willful default of the default on the part of the said respondent. First, next, having heard the learned counsel for the parties and having perused the complaint papers, we are of a considered view that there is a direction in terms of which goods are to be released is true. First, however, the proceedings under the provisions of GST Act are to be processed, and for that purpose, as a matter of state policy, release is possible where the bank guarantee is given for the worth of the goods in question. First, there is another point that goes against the complainant in as much as he had specifically told to the third respondent by in writing dated 22/9/2023, a copy whereof avails at annexure R8, that the cost of the goods in question, the value of the goods in question was 46,29,487 rupees and not rupees 3.36 crore. First, therefore, now he cannot say that he will not give that bank guarantee for the worth of the goods. First, this apart, the value of the goods is now shown to be less than what the complainant himself has quoted in his letter dated 22/9/2023 at annexure R8. And now, because of the latest letter issued by the third respondent on letter
6/3/2024.
6/3/2024, it is rupees 13 lakh
36,194.
36,194 for first. Therefore, the petitioner, the complainant can get the goods released on giving a bank guarantee for this lesser sum. First, with the above observations, the complaint petition is disposed of.
Your lordship, subject to the guarantee that they will release the goods by paying the
third respondent shall release the subject goods on the complainant furnishing the bank guarantee as indicated above. Okay.
26.
I appear for the accused, Lord. We have filed counter affidavit stating that the status quo order is up.
We are dropping it.
For the complainant, I am appearing for the complainant. My lords, there has been a willful disobedience of order dated 28/3/2020.
Go to the counter in other proceedings, the interim order is passed.
Yes.
Learned a single judge by order dated 28th March 23, directed respondent for Tehsildar to consider the application of the petitioner dated 15/3/2004 as also the representations dated 13/2/23 and 6/8/22. The request of the petitioner was to grant the land in the capacity of ex-military personnel. It is the said directions which are brought under the contempt jurisdiction of this court. Paragraph in response to the issuance of notice, counter affidavit came to be filed by the respondent accused, in which it is entirely stated that once Sri Aditya Narayana has filed writ petition number 20021 of 23, in which this court has passed the following order. We quote the order at page 2, left, below left, keeping in mind the rival submissions. Thus, there is a direction after quoting to maintain status quo with regard to the subject matter land, which is claimed by the complainant herein. Full stop. Since the order of status quo is granted and is operating in the said another writ petition, it cannot be said that the respondent have committed any willful contempt of the directions complained of. Full stop. The facts and circumstances, no purpose would be sought to keep the contempt proceedings live against the respondents. They are hereby dropped, reserving liberty to the complainant to have a recourse of the appropriate remedy after, at a future point of time, if as the need may arise.
My lords, they have not given me the counter affidavit. Counter affidavit that has been filed. This is only brought to my notice today while I was standing here that they have filed a counter affidavit.
But
That's
now
why
it is given.
They have sent it to your client.
Post facto.
Obliged.
December 27, Stage P Gangesh.
Serial number 27.
Pay for the appellant, my
I have instructions to appear for respond number 1 to 5. What happened, my lord? Since my name is not shown, my lord, I could not get ready. And I received the copy of the writ appeal papers. 1 to 5.
Mention the name of learned senior advocate, Mr. So while notifying the appeal.
there are
on
two
the next
IAS.
Stand out to 3rd
Yes.
April.
I have filed.
IR is there.
Condonation
3rd
of
April,
failure.
interim leave granted. Where is the interim leave? IR is there.
There is a delay of 78 days in filing the appeal, my lords.
IA. So, issue notice in IA.
Notice were ordered, my lord.
My lord, all
On
are
that
served.
day
Well, I'll get ready and argue the
On that
matter,
day
my
we
lord.
go.
Any date convenient.
And I've
Second
also
April,
filed
2nd April.
an IA for stay of the orders passed by the
On that,
learned senior.
on that day. Since the other side is seeking time, on that day we'll consider IA as well as.
Because
your prayer for it.
there is a possibility of filing the contempt petition before this honorable court, my.
So it will come before this court only.
Please.
Second April. Number 28, Sunil Kumar S.
Petitioner in this.
I am for response 7.
That's filed IA number 1, indicating seeking the proposed respondent number 10 to 14 millets, as well as respondent number 7 has filed an objection stating that millets were not made a party to proposed respondent number 10 to 14 millets, as we have made a chief secretary of highways as a party millets, as under we have made secretary of Government of India, Ministry of Road Transport and Highways as respondent number 3 millets. Now the respondent number 7 has filed this objection stating that millets we have not made a party to the undersecretary and reason as a proposed respondent number 10 to 14.
What's your prayer?
Millets, our prayer is that millets we are seeking the consideration of our representation, because millets as per we are the residents of millets were the residents of one cantonment area of Ballari.
Sunil, who should consider your representations?
Millets representation shall be considered by the respondent number 1, 2 and 3, my lords. And including 5 millets, Principal Secretary of Public Works, PWD.
You consider that who is that respondent? Consider those representation, tell whatever you want to say.
My lord, it
You
may
want to
be,
respond to the representations of the citizens.
yes, my lord.
Read Article 350.
Yes, my lord.
Then
I am for the respondent 7. They have filed one writ petition against a proposal of a construction of a road, my lord, which is,
they are here with the grievance that we have given representations. We are entitled to have the result, the fair consideration of those representatives. Because there is a constitutional mandate. Constitution says any citizen can give a representation to any authority and the authority has to take a decision on that.
yes, my lord. I too agree, my lord. But they have not approached the competent authority, my
You
lord.
send them to competent authority.
Yes, my.
Tell them, we are not the competent authority. You go to the competent, this is the competent authority. That also you don't say.
It is well said, my lord. Notification is given 21 days before itself. Notification has been sent, and we have talked with them and asked to send the representation to their competent authority, my lord.
Short.
Just on one point, my lords may kindly hear me. I appear for the Secretary, Ministry of Road Transport, my lords. The grievances of the petitioner, my lords, I am deeply obliged to what falls from my lords, that we must in all entirety address and redress every grievance that a citizen of India may have, my lords. This is a public interest litigation, is not adversarial in nature. I bow down to my lords. But my lords, all of the petitioner's grievances, my lords, are admittedly considered as per the annexures appended by them. Lords may kindly see page 185, my lords, the annexure to the writ petition. Lords, the main grievance appears to be that there will be traffic and that the angle of the road is not this way, the angle must be that way. My lords, though I bow down to what falls from
Where
my
is
lords.
that?
My lords, page 185, my lords may see detailed surveys on all of these aspects are already considered.
No, they are saying, they are suggesting in those representations alternative proposals. On those alternative proposals, you have to take, brother, it's not possible. We have examined your representation, not possible. Even 2 sentences, you are ours is a welfare state, not a East India Company.
I'm obliged.
You should consider the representations and tell them the result of consideration.
My lords, my only difficulty, my lords, is this. One aspect, my lords, is that if the representation, my lords, is touching upon an issue, my lords, not already considered by an expert body, then, my lords, I entirely bow down to what falls from my lords, that we must consider it. But all of these have been considered, my lords.
You should tell that only as a response to those representations, so that they will not waste their time, public time.
My
of
lords,
the court,
and
etc.
another, my lords, I know that in public interest matters, we must not border on technicality, but my lords may kindly see the representations. It is, my lords, at page 326, my lords. My lords may take 326. 323, my lords. May I request my lords to take 323.
And simultaneously, my lords, 323 and 336. May I request? (323), my lords, and 336. Lords, I found something to be very peculiar in these matters. It is not their case, my lords, that a common letter was given to all the authorities. They say 9-10 different letters were given. But if my lords may see the table, in 323 and 336, it's the exact same table. How is it possible, my lords, that if multiple representations are issued to the authorities, how is it that the signature is exactly the same? The table is exactly the same. I don't even know, my lords, whether these representations were given. And my lords, another issue is they claim to be an association. What is the relationship between the people who have given these representations and this association, my lords? I'm not aware.
All that you can say in your response to the representation,
I'm
instead of
obliged,
arguing here.
I'm obliged.
The petitioners are invoking the PIL jurisdiction of this court, grieving against non-consideration of their three representations respectively at copies whereof are respectively at annexures K1, K2, and K3.
My lord, they are all sketches, my lord.
Huh?
They're all sketches.
Sketches.
M1, M2 and
Sketches.
M3, my lord. Our representation is M1, M2 and M3, my lord.
M1?
M1, M2 and M3, my lord.
M1, M2, M3 in terms of sketches at annexures K1, K2, and K3, wherein they have suggested an alternative proposal. First, Learned Counsel for the petitioners argues that there is a constitutional obligation resting on the authorities in terms of Article 350 to the effect that whenever a grievance is raised by a citizen, that should be addressed by the concerned authority one way or the other, and further, result of consideration should also be made known to them. First, this duty, according to the counsel, having not been discharged, these clients are more than justified in complaining before this court. First, Learned Counsel appearing for the respondents opposed the petition, contending that the consideration of the subject representations would be futile in as much as there is already a decision taken as is reflected in pages 185 and 186 of the annexure. Which annexure it is?
Lords, annexure, my lords, I'll just point out.
Annexure C to the very writ petition, and therefore no consideration need be undertaken. First, next paragraph. Having heard the Learned Counsel for the parties and having perused the petition papers, we are of the considered view that the representations of the petitioners do merit consideration at the hands of the answering respondents. And this having not happened, the petitioners are justified in invoking the PIL jurisdiction of this court. First, this court in a series of judgments has taken the view that when a citizen raises a grievance, such a grievance has to be addressed by the concerned authorities, and result thereof should be made known to them within a reasonable period. First, next, in view of the above, this writ petition is disposed of, directing the respondents. Which respondents?
Lords, I'm for the
jurisdictional respondents to consider the subject representations in accordance with law and to inform result of such consideration to the petitioners by speed post within an outer limit of 6 weeks.
Obliged.
First, it is open to the answering respondents to solicit any information or documents from the side of petitioners as are required for due consideration of the subject representation. First, we have not expressed anything on the merits of the representations.
One submission, one request, till consideration of our representation, my lords, they cannot continue with the, my lords, because now they are conducting the survey and also they are marking the properties.
That will happen. It cannot happen. Well, it happens in eminent domain.
Obliged, my lords.
29, Mohammed Shamil.
Complainant, my lord. This matter we have complied the order. On the last occasion, we filed a memo.
But I have just one argument to make, my lord. I am the absolute owner of about 9 acres, 10 guntas of land. I purchased it under two I'm the absolute owner of two extents of land. I purchased it under two separate sale deeds, one a sale deed and one a sale certificate issued by the DRT. My representation before the Tahsildar, my lord, which my lords will get,
So order
at
is
page
not-
98.
Any order is passed?
Yes, blood, I have produced blood mutation register extract.
RTCs are filed, my lord. My
And the
request.
RTC on the last occasion along with a memo dated 15/2/2024.
My request before the authorities, my lords, was to reflect my name in the RTCs. They have instead shown the names of my predecessors in title. Of course,
The order is to consider.
Yes.
order is to consider. No doubt about it. I bow down to that, my lord. But the only difficulty, my lords, is to get to this point. I've taken 1.5 years of filing a writ petition, and filing a contempt. If it is left at names of my predecessors in title shown in the RTC, I may have to repeat the entire process. So I'm really at the mercy of my lords if some consideration can be shown by the state.
Where is your response?
But I filed a memo dated 15/2/2024.
Only says that
Enclosing
enclosing.
RTC and mutation register extract. My apologies, blood, translated copies are not produced.
So RTC's request, RTC in respect of land in question, extract of mutation register.
Yes.
Mutation has taken place now.
Yes,
And
If you are
names of my
agree, we can
predecessors,
challenge that.
names of my predecessors in title are shown. My name is not shown, my lord, of course.
Go to the, you challenge this under 136.
I could, my lord, I definitely could file a revision, but as I said, my lords, I'm at my lord's mercy. I've taken 1.5, it's taken 1.5 years for them to show my name, the names of my predecessors in title. I'll be made to run pillar to post again to have my name included. Ultimately, my lord, I'm a owner under a registered sale deed. All they have to do is show my name.
I ordered dated 30th August 23, learned single judge dispose of the writ petition to direct respondent 4 to consider the representation of the petitioner and to pass necessary orders within stipulated time of 8 weeks. The representation was to be considered in respect of the request of the petitioner contained in letter dated 18/1/23 relating to land survey number 130 and survey number 130/2 capital A situated at Bombay Nahali village, either Hali, Hobli, Bengaluru East Taluka. Learned Government Advocate Mr. Mahindra invited attention of the court to the memo filed by him in which the RTC in respect of land in question is produced. First of also produced the extract of mutation register of the land in question. Also, the said memo and the documents annexed herewith evidences the compliance of the direction of the single judge. In that view, nothing survives in the present contempt application. It is accordingly disposed.
Liberty may be resolved.
If the complainant is aggrieved by the decision, it is open to him to institute independent proceedings in respect of which this court does not express any opinion on merits.
Number 30. To Vignesh.
Also, direction to pay the compensation at ink page number 13, my lords, within a period of 2 months, and year and a half is over. Lords, my lands were acquired. They said that 50% you take developed lands. I said, I don't want developed lands, you pay me compensation. But the Leonard Singhal directed that you cannot insist that I should take the lands, give him the compensation at the calculated rate as per the award. Award amount is not paid. Notice is already ordered on the government notes.
Government has to pay.
Yes, compensation notes.
Compensation, you have taken the land of the citizen.
PDA.
BDA.
PDA notes.
PDA is answered.
The lordships had directed, notes, the government advocate on the coordinate bench had directed, because it's only payment of compensation, deputy commissioner has to pay the compensation.
But whom you have made the party?
Notes, the state as well as the commissioner of BDM, notes, they were the respondents before the Leonard Singhal judge.
Read a cast title.
Lords, at annexure A, page 9, Lords. State, then BDA by its commissioner and the special and action officer. In the present contempt petition, the incumbent commissioner and the state. Is it? The first page, Lords.
You are right. None appears for first accused.
Lords, notice, I checked from the order sheet, Lords. Though the coordinate bench had directed, but it is not reflected in the order sheet, Lords, regarding the first accused. So
Notice
therefore, I
has
have to take notice on the first accused.
But it is number 2 is responsible to comply or number
Lords,
1?
two, one has to make the recommendation based on which 2 will, because award will be dispersed only by the state.
Notice to the respondent 2 only. Returnable on second.
Your Lordships may direct notice on both the response, because they have to make recommendation based on which the award will be dispersed.
So notice to all the respondents.
Lordships.
Returnable on which date?
Lords, next
15.
week, any date. Lords, the payment of compensation is held back from the past over 6 years.
1st April.
Lordships.
1st April.
Great.
Learned, you are waiving, accepting for number 1.
You accept notice for number 2.
2, Mala, pro forma.
2 AG. It becomes 2.
Learned advocate for learned government advocate, the Mahindra accepts notice for 2. Respondent 2.
Issue notice to.
Great. Number 31.
Wait, please, your lordships. Should appear with the appellant's counsel. Sir, this pertains to the many wage notifications where the honorable single judge had quashed the notifications without. We were not implicated as parties. We are seeking leave to appeal. We don't know what respondents we are. It's like office objections. We have filed separate court fee has been paid
By 0.
for each of the appellant.
Your Lordship,
But
serial
my
number
lord has
50.
already ordered notice. One problem in this case, my lord, I want to place before your lordships. The notifications are quashed. 22 notification also, 2022. In the meantime, what notification I should follow now, my lord? No arrangement is made by the honorable single judge. Simply, notifications are quashed, which I have been following for about quite some months, up to September 23. If that is quashed, what notification should I follow? The lordship should have said, continue to follow this until you come with a new notification or some arrangement. Otherwise, we will be in a quandary.
What happened to my judgment, the apex court?
I
had argued that matter before me.
No, that is, I don't think they have granted leave.
Huh?
I don't think they have granted leave. Only notice has been ordered, I think.
So here also notice has.
How? It must be clubbed along with.
Your Lordships, kindly, the serial number 50, connected matters are being heard.
Asim Industries, my lord's judgment has not been paid.
Having heard learned senior counsel, assisted by learned notice to the respondents, returnable on after vacation.
Serial number 50 is also there.
Lord, I appear in item 50, my lord.
Same order.
Serial number
Same order.
50. Your lordship
And then,
have
Lord,
already
one
entertained it
aspect
and
is,
granted
my
it.
lords must say,
Order.
Can be
we have to
called along
protect
with
the interest of the workers. Suppose the employer says, "Well, notification is quashed, I won't pay, I'll go back to the 2016 notification." Some arrangement has to be made.
But one small submission.
In the interest of workers at least.
In your matter, there is interim order.
Yes, my lord, there is interim order.
Not to precipitate.
Not.
That's how
Interim
interim order.
That's right.
Only.
Same order can be done. But my submission is,
So the respondents are directed not to precipitate the matter till the next date of hearing.
Sir, may I make one submission?
same order.
Same, identical.
Item 50 is the batch Item 50, my lord, may I say this, my
It shall
lord?
be listed with
My lord, there are some.
writ appeal number 23 or 24.
But this matter can be disposed of on a very short point, my lord. What has happened is that this is an exercise of power under section 5(1)(b). Learned judge has proceeded on the basis it is 5(1)(a). And employers are not heard. So it will have to go back, my lord, for
No,
adjudication.
I'm very sorry, my lord. My learned friend is maybe right.
There
One
are other-
aspect, full
there
bench
are-
of this court has said,
There are,
if your judgment is passed on merits, your lordships cannot remand it.
let us see, there one question is
That's your lordship
whether,
judgment.
whether the principles evolved by the apex court in Reptacos are
Exactly.
they applicable while fixing the
My
wages
lord,
in
that has become
respect of
infructuous. my lord.
non-scheduled?
1990,
That's all it. That's one question. Therefore, the matter requires consideration.
very
Well,
well.
item 50 is all for
That
final.
let has become irrelevant now. So many things have happened.
My lord,
My lord, item 50 is the batch of cases, which is, this is connected with that. We are ready in the matter.
Yes, give the list of cases. We'll hear all those matters.
In item 50, my lord, there are 26 matters. They're all connected.
We are ready in the
All
matter.
are listed.
My matter also can be clubbed and they all can be posted.
We have
for
clubbed
hearing.
now
Please.
There are 17 of my connected matters.
with this only.
Yes.
50.
Serial number?
50.
They are covered under 50 only. There
We
is-
are ready in the matter, my lords.
Oh,
My lord, I appear, my lord, for the first respondent in 50. And my lord, we are ready in the matter. I'm under the impression the matters will be taken up today, my lord. We will assess the court. We will
Today,
assess.
we have difficulty. We have already fixed certain other matters to be taken up. We'll give some other date, subject
But
to
I-
your convenience also.
Could I request a very short date, my lord, because matter pertains to minimum wages.
All right.
Your lordship may, the matter of minimum wages, your lordship
When
knows.
it is kept. So it can go to 15th April.
I'm grateful.
Same interim order for me.
Yes.
Yes.
Lordship.
Subject to them abiding by the previous notification or whatever it is.
Yes.
Prior to, it has to be,
Huh? Which any other matter, if they are pending, give list a list of that also.
Number 32. G. Kumar.
Correspondent 1 and 2.
But I have the office objections, my lord. The objections, my lord, I have already served the copies on the learned friends, my lord. All the respondents are served. The cost title should, cause list shows, my lord, the copies are not served on so. I have already served today, my lord. Matter is relating to, my lord, transfer. Lord, the appellant who was posted in the place of fifth respondent on his suspension. On his suspension. Lord, the learned single judge, my lord, please to allow the writ petition and permitted the
Suspension is continued for 23.
fifth respondent to continue in a mischief area, which is impermissible, my lord. So on that ground, my lord, I have approached the.
Suspension is continued up to?
But suspension order was challenged before this honorable court, and this honorable court has quashed the suspension order as well. Since it is a mischief area, he should not have been continued in the very same place. Lord, as per the honorable Supreme Court's order, my lord, I have cited in the present writ appeal, my lords, which was canvassed before the learned single judge also. Lord, that has not been considered, and the writ petition the transfer order has been quashed, my lord, and the respond number 5 petitioner was continued in a mischief area. Where, my lords, now I have been rendered without any posting, my lord. Now.
What happened in the criminal case? Any kind of
It's still
charge sheet
pending,
is
my lord.
filed now?
No, my lord, the FIR is registered and they had to proceed with the inquiry, my lord. The trial has to, but charge sheet has to be filed, my lord. Still, it's, my lord, the issue was more, my lord, on 19/11/2023, my lord, the fifth respondent was suspended on the ground that, my lord, there was an incident took place in Whitefield, by which, my lord, the one mother and daughter died due to, my lord's electrocution. That in
Restriction.
yes, my lord.
Correct.
My lord, that matter is, my lord, matter of trial, my lord, that is FIR is registered and matter is pending before the jurisdictional police for further investigation is going on.
Correct.
Yes, it's in investigation stage itself. But in the meantime, lords, the authority, lords, passed an order of suspension, lords, which was challenged before this honorable court in writ petition number 27438.
Yes.
27348 of 2023. Learned single judge, my lord, pleased to allow the writ petition and pass the suspension order. Thereafter, my lord, so the petitioner, the fifth respondent, my lord, sought for continuation in the very same place, my lord. In the meantime, Lord, I was posted and I was discharging my duties as Assistant Executive Engineer in the Whitefield. My posting is subsequently challenged in 1205 of 2024.
Yes.
That writ petition also came to be allowed, saying that, Lord, since the suspension itself is gone, Lord, the transfer of this appellant to third place, Lord, is quashed and permitted him to continue in the same place. Where is, my lord, the very same post place is, my lord, is a mischief area for the very same respondent number 5. The Honorable Supreme Court is pleased to.
Years your client was there in the post in question?
19/11/2023, my lord, the fifth
Didn't
respondent,
happen.
yes, 19/11/2023, respondent number 5 was suspended, my lord, and I was given posting on 27/11/2023. 27/11/2023. My lord, I was discharging on the order which, my lord, posted me is 27/11/2023. That was challenged before the learned single judge, in writ petition 1205 of 2023.
Correct.
Within 2 months, my lord, the writ petition, my lord, is allowed and my transfer order is quashed and he is permitted to continue in the same place.
Because in fact, he was not transferred, he was only suspended.
Yes, my lord.
And he was not supposed to leave the quarters also.
Yes, my lord.
Under the suspension order, under
Yes.
our rules. He was supposed to be in the quarters only.
Yes,
Rules
my lord.
provide
Yes, my
that
lord.
way.
He was given posting in the headquarters.
And you knew that because he is suspended, you are being posted because office cannot be in vacuum.
Lord. Correct, Lord.
Now
Lord,
suspension order has gone.
Lord, since
So naturally, he has to be given his place.
Lord, he was given
What is
posting.
your grievance?
My lord, he was given a posting in Bangalore itself, my lord. My lord, that, my lord, he has not gone and reported there. He came before this honorable court and during the pendency of the writ petition, Lord, he was given posting somewhere nearby.
Anyway, it was
within
not a
city
general
itself.
transfer. It was not a general transfer.
It was not a general transfer, my lord.
Transfer took place in the
kindly-
light of under the shadow of the suspension order.
Yes, my lord.
Now that suspension,
But
that shadow has gone. now.
serious allegations are there, my lord. That's the reason, my lord. He was kept in the suspension order. My lord, is quashed. It was in a premature stage itself.
His client was suspended. He set aside this. Pursuant to that. Client was placed into charge. No suspension order is set. Just in 2023, 27/11/23, you were posted there.
I was posted there.
Anyway, 1 month this side or that side. Even going by your version also. Now, because it was in the light under the shadow of the suspension order, you were posted there.
Yes, Lord.
Suspension
My
order is quashed
order,
now.
my order of posting is at annexure. E
Anyway,
page
there is no
40.
dispute on these facts at all.
Please, my lord.
What is the litigable right? What is the grievance?
Lord,
If you go to other place, you
kindly-
are paid your full conditions of service or protection.
no, my lord, kindly come to the suspension order. is passed on the basis of the report submitted by the committee, my lord. That is produced before this honorable court and by the board itself, the corporation itself, my lords, on page 74, annexure R3.
Page number?
74. I have prepared a copies, my lords, which the translations are also placed along with the writ petition, my lord.
What is, you said that?
Yes.
Because of death of mother and the child,
yes, my lord.
He was suspended.
Yes, my lord. Since it is a mischief area, he cannot be continued on. I'm relying on the judgments passed by the Honorable Supreme Court, my lord. Kindly, I have compilation of the Supreme Court judgments, my lord. I may permit it. First judgment, my lords, 1993 supplement 3 SCC, page 483, my lord. Relevant is that paragraph number 10, page 5, may kindly. I have extracted the judgment also in the writ petition, writ appeal, my lord.
What was your retention period there? Under the transfer guidelines?
2 years.
2 years.
2 years, my lord. It's a group
2
year
years.
post. Yes.
That period was not over.
It was not over.
27 May 22, I was posted there.
The retention period. Which is that full bench which said the transfer guidelines are mandatory?
Yes.
H.N. Gangadharan. H.N. Gangadharan. Yes, bro.
Chandru and S.N. Gangadharan.
H.N. Chandru and that is, my lord, page 32. The writ petition, my lord,
Understood.
Challenged in this writ appeal is by the person who was posted in the place of writ petition.
The virtue of his suspension.
So this operates in your favor?
He is displaced. Post of his respondent. He was posted.
Once the learned single judge has this, once the learned single judge quashed this order of suspension, allowing the petition, comma, all legal consequences are bound to follow. The direction number 3 in the operative part of the order of learned single judge is in a way redundant, that since there is no question of reinstating
So not a case of reinstatement.
full stop, the employee was already in service
Only
and was
submitted.
only under suspension, which now has been posted. Full stop.
He says, no posting given to him. We can direct him. When are you going to give the posting to him?
My lord, what has happened in view of the quashing of the very order by which the appellant was posted to Whitefield, that he'll have to report back to the corporate office.
He's given posting also.
No, my lord. As of today, my lord, my instructions are he's not. My
You
lord, if he
give
reports,
posting.
please, if he reports to the corporate office, my lord, we'll
Learned
accommodate
counsel,
him.
Ms. So-and-so for the respondent number,
Respondent 1 and 2.
Karnataka Power Transmission Corporation.
Please.
Stated that pursuant to the posting of the suspension order, the necessary posting shall be given to the petitioner as well
A petitioner will be there.
Mm.
Appellant has to be
to the appellant.
appellant.
My lord, and the appellant has to report to the corporate
Provided he
office.
reports in the matter.
Full stop. Learned advocate Mr. So-and-so for the appellant said that he will report for duty
Yes.
at the post, at the place of posting intimated within 15 days,
Week, my lord.
within 1 week or 15 days. So respective parties are directed to act as per their statement made before the court. No further order are required in this writ appeal. Accordingly, it is disposed. That's all.
Obliged.
Matters, my lord, the appeal has been admitted by an order, my lord, of 10th February 23. Matter will have to be heard. There is also an interim order operating. The other side had been for vacating interim order.
They are all farmers. Pomegranate, trees were there, we cut it saying that we have solar panels and all that. 2 writ petitions, my lord, filed by, my lord, cancelled our PP. Let aside by this honorable court twice. Challenging, my lord, the 3rd order.
There's a direction given, my lord, that they must be permitted to continue into the old PPA and they must supply at 9 rupees an odd when the current rate is 3 rupees.
All covered by judgments of this honorable
That's
court,
the issue.
confirmed by the Supreme
They have not started the work. There's no building. This is a rooftop solar scheme. There's no building, there's no
Within
roof.
3 months, my lord, of my starting the
Nothing.
work, my lord, they come and send the police. My lord, that is what, my lord.
Matter may have to be heard early, my lord, I have no difficulty. All the appeals are admitted.
No, what we are, what are your contentions? We'll hear this matter and.
I'll begin, ma'am, please.
Yes.
Lord, kindly take writ appeal 1274.
Yes.
Yes, yes. The group of Only one.
No, two.
Two.
Two
There are
matters.
not two volumes of books, filings in this appeal.
Only 7 matters.
There are in all 7 matters.
Yes.
1274. In that, not at page 93 is the power purchase agreement. Can we see the heading at page 93 at the bottom of the stamp paper? Power purchase agreement for rooftop solar PV plants.
That's for a period of 25 years.
Yes. At 94, the power purchase agreement is entered into by so and so with Bescom. Then Viraya, the consumer, in survey number so and so. Then first recital, whereas the seller intends to connect and operate the solar rooftop photovoltaic system with ESCOM so and so in terms of Electricity Commission order dated 10/10/2013 as amended from time to time. So, my lord, this order is the order by which the Electricity Regulatory Commission fixes the tariff that is to be charged. My lord, as a distribution company, when I buy power, my lord, from a generating company, the price at which I buy the power is regulated by the Electricity Commission. So, by this orders, they fix the tariff. And they say that tariff is to be amended from time to time. Then, my lord, B, the seller intends to install and has installed a solar rooftop photovoltaic system, short form is used, of 1000 kWp capacity on the rooftop of premises situated at Venkatapura, Pavagada, so and so.
No,
to
what's the
connect
ground of
electricity.
attack in the appeal?
Pardon me?
These are the terms of the agreement.
No, I'm
This is
just
all
pointing
right.
out some essential facts, my lord. These are essential facts because I'll tell you, lordship, not what my submission is. My submission, my lord, is this. These persons, they entered into the power purchase agreement. They did not take any steps. They did not put up the building. They're not even perfected the title. They're not obtained. Please. 19th, my lord, 1 minute.
Whichever date.
Whichever
18,
date you
19.
want.
One or 2 days accommodation.
3rd April.
3rd April.
Would it be in first week of April, no, or 20th?
20th.
3rd April.
3rd April, all
Please,
right.
please.
Number 34.
This is the disposed of matter, my lords, where your lordship has to dispose of on 2nd January 2024, directing to hold the election within a period of 8 weeks. My lord. In fact, for Davangere, we have held the election. Only for micro Chamraj Nagar, we request for some more time.
Extension.
Extension.
How much extension you have sought for?
We have sought till the end of July, my lords. Anyway, the one more thing is, my lord, by tomorrow day after code of conduct also is likely to come. Because of that, we may not be in a position to hold the elections also, my lord. So within 15 days after the code of conduct is elections are over, within 15 days thereon we'll hold the election. My lord.
Code of conduct is not started to process. We better pass the order when code of conduct is
We will
operational.
call this matter in the first week of April so that in the meanwhile we will know. If that is so, that will.
I'm grateful to my lord.
In anticipation, we not.
No, the lordships are absolutely right. For first week or second
We
week.
appreciate your stand, but let the right.
Because if I say please.
My name is not shown, my lord, for R4.
R4, please.
Kiran Kumar TA.
Name to issue.
My lord, may I have date?
Statement.
Date, 3rd April.
Number 35, the Jeevan Kumar BS.
This is complied with. Possible.
Complied. Not complied.
Somebody wrong.
Jeevan Kumar BS.
Notice as to.
No.
Two 19 days.
290 days in filing.
219 days.
Delay in contempt. So he is not there. 2 weeks.
Whether any provision in the contempt of courts act for condoning delay?
No.
No.
There is no.
There's no
1 year is
Section 10 or 20? 10.
20.
20.
The preliminary matters, number 36. Sujata.
For the government.
None a single judge has quashed the final and preliminary and final notification. This is a scheme in respect of Anjanapura layout.
Similar matters we entertained.
Yeah, my lord, serial number 9, today's matter is listed.
Posted also.
Yes. 17 years.
Identical matter.
Yes.
There are three matters.
Yes.
Yes.
In today's vote.
Today,
Today
one
number
matter.
9, I'm told that today serial number 9 matter is listed.
What happened in 9?
It is
Urgent
agent.
for
Just for
It's agent
office
for 3
objections.
weeks.
Office objection.
So this can be admitted.
Great.
Heard learned advocate, Mr. You are Mr.
Sachin.
Sachin.
Yes.
For the appellant and learned.
I'll take
additional
notice for our
government
form.
reports. Appeal deserves to be admitted accordingly. Be posted for final hearing. It shall be posted for final hearing.
Delay there, no?
18 for other matter. 18 for.
Grateful.
On that day, at least we can club all the matter.
Otherly entry matter then. Fresh matter. Ali, waiting for it.
So we may not take up on 18 for. but
Status
we club.
Some date after clubbing we will decide.
Yes.
Number 37. The Sanjeev BL.
This matter, my lord, the respondent, my lord, was working as a driver. My lord, he caused an accident, my lord, for which in a minor punishment, my lord, of 1 increment for 6 months, my lord, was imposed. And thereafter 17,000 was the damages caused to the bus, my lord. That was asked to be recovered.
Without inquiry.
No inquiry, because minor punishment, my lord, was imposed.
But
The
minor
court-
punishment also requires inquiries.
No, my lord, notice is to be issued, my lord, call for record. That has been done, my lord. The court comes to the conclusion because of the inquiry, my lord, page 7, my lord, is the order passed by this honorable court.
But another coordinate bench said, even for imposing minor penalty,
My lord,
inquiry is a must.
the
Just
regulation, my
cross it.
lord, the honorable Supreme Court says, if the regulation is there.
No inquiry need to be taken place. Taken.
Inquiry means, my lord, preliminary inquiry.
What is the penalty?
Notice is to be issued, my lord.
Minor,
and
one increment.
1 increment, my lord,
Without future effect.
without cumulative effect,
Without cumulative.
without cumulative.
Correct.
Yes.
And
Which paragraph?
My lord, para 16, my lord, may I request? Here, the delinquent officer was given an opportunity to reply to the show cause notice which was considered and the board took a conscious
No,
decision.
there is difference in service law. Proceedings initiated for a major penalty, but minor penalty came to be issued is one scenario.
Yes, ma'am.
Proceedings ab initio is for minor penalty is another. If it is for minor penalty from the beginning itself.
From the beginning, regulation 22 of the.
You have put it in the.
Yes, yes.
Where is that?
Regulation, my lord. Request, my lord, 42, my lord.
So you initiated the proceedings only for the purpose of imposing minor penalty.
Minor penalty.
There you show that.
Page 42, my lord, is the order passed by this honor, the court below.
Your rule must be distinguishing the procedure.
Yes.
For minor and major penalty. To be undertaken. Page 42.
Yes, ma'am. English. Lord, as per regulation 18A3 of the
No,
43 is the.
This is an order.
Order imposing minor
No,
penalty.
that is also.
But initiation of proceedings.
Yes.
Should be for minor penalty. That you should
Charge
reflect.
sheet was issued on that ground only, my lord. I have said it in my petition also. And
You show the show cause notice.
Show that show cause notice.
show cause notice, my lord, I have not produced it. Not, I have not produced it. My lord. I have not produced the show cause notice.
Notice is not issued. You have not issued. Well, issue notice. In the
I'll
meantime,
produce
you
it.
produce.
Produce show cause notice so that we will know that.
I'll produce.
Straight where they have said that inquiry in this case is not necessary. Anyway, you produce whatever. Our learned advocate, Mr. Sanjeev BL for the appellant. Notice to the response, full stop, notice returnable on.
Caveat to this.
How many? Only one respondent? It must be one on.
One respondent.
How this? One month.
Only one. When returnable on? April.
18th April.
18th April.
Where to stay? Stay up.
You sought for stay?
Yes.
Sought for stay.
With what stay? It is. There is no question of granting.
I'll
any.
produce.
May I make a mention, Malad? Serial number 60, Malad, may I seek for an adjournment, Malad?
Adjournment.
Serial number 60, Malad. The council was here, Malad, but due to some uneasiness, she had to leave the court.
Done.
Serial number 60.
It will go now in April. All my.
I'm not feeling well.
You can have your date.
May I make a mention, my lord?
Yes, Krishna.
My lord, serial number 43, my lord. May I seek for a week's time in this matter, my lord? Kindly have it next week.
In April, Mr. Council.
Please, my lord, any day.
All dates in April.
Apply.
Your Honor, serial number 52. Not accommodation.
Said that, no?
Congratulations.
Number 38.
Lord, I appear for the petitioner in this case. Essentially, there are two contentions raised. One is regarding petitioner father had a quarry lease, Lord, which was granted in 1998 for a period of 10 years till 2008. He applied for renewal within time. It was granted, my lord. Notification was issued in 2012. But unfortunately, the required clearances like environmental clearance, conversion into, my lord, non-agricultural use, etc., was not given to me within time, though I had applied for all of them. The then Rule 18, my lord, as it existed in 1994, at that relevant point of time, said, may I read? Book. I have old book there. My lords have 1994 rules, my lord. 94 rules. Illandre, I can, if it is not there, my lord, I have one copy. Can I pass on? I have one more with me.
I have extracted the same in statement of
No,
object.
no. Your extraction is the latest rule. I'm talking of the old rule as it existed. Let us be very clear on that. 1994 rules, rule, my lord, 18.
Rule 18.
Yes, may I read with the leave of the court?
18. 18.
18. May I read, my lord? When a quarrying lease is granted under Rule 11, lease deed shall be got executed in Form E by the grantee within 3 months of the order granting or renewing the lease, or within such further period as the competent authority may allow in this behalf. And if no such lease deed is executed within the aforesaid period, the order granting or renewing the lease shall be deemed to have been revoked. Now, my lord, 3 months' time is granted for me to get the lease deed executed. But conditions, my lord, are, first I am broadly stating my case and I'll take your lordships to the relevant documents. Conditions in the grant notification is that I must get all the necessary statutory clearances, like conversion of the land from, my lord, agricultural use to non-agricultural use. Number 2, environmental clearance, etc. Impact assessment study.
Their prescription under which rule?
Under the conditions, my lord, they have stated so. Notification granting, my lord, the lease in my favor.
Are you speaking about renewal of the lease?
Renewal notification was granted in my favor.
No. Mr. Rao.
Yes.
We said there are certain clearances, certificates, etc.
Yes.
Which are to be produced as a sign for non.
That is
for getting the renewal or for getting the grant itself.
That is mentioned in the notification itself, my lord.
Which notification?
Annexure E. Kindly take Annexure E of the writ petition, page 92, my lord. 99. Annexure E 101.
101 is the English version.
Not 92. 101. My apologies. 99 is the Kannada version. The English translation, my lord, is at 101. My lords get that. As per Rule 11.4, Lord, the then rules said when we apply, it will go before the committee, my lord. The committee recommended grant of renewal in my favor. It is thereafter, as per Annexure D, it is thereafter, my lord, a notification is issued granting this particular renewal, my lord. Sub-rule, my lord, at 102, sub-rule 3A,
Where this mentions that what all to be produced by you?
my lord, at page 103, conversion order is mandatory. Item N at page 103.
Last page.
That is regarding conversion, my lord. And environmental impact assessment at annexure F, page 104. May I request your lordship to see 104.
Page 104.
104. This is state level environmental impact assessment authority. Kindly note the date, my lord, 4th of December 2012. After the period of 3 months from the date of grant of notification. Conversion order.
No, we wanted to know.
Yes.
You say conversion order is spoken of at last point in page 100, Kannada.
Yes.
That we can understand.
Yes.
That apart, what are all to be obtained?
My lord, at page 102, item J.
Mr. Rao, when you are ultimately seeking the deemed extension.
Yes, what
Deemed
happened?
extension.
Deemed
The
extension,
deemed
I am asking,
extension amendment rule came in 2016.
2016. All the
That-
leases
On that
granted,
day, your original period was already expired.
true, my lord, but what the law said into that amendment is, it shall stand extended for a period of 30 years originally from the date of the grant.
Is it so?
Yes, my lord.
The language?
That's
No.
the language.
Let us.
Thereafter, in 2023, it is extended, my lord, till 50 years. I'll show both the rules for your lordship's kind consideration.
If it is extended,
Even expired leases are also extended.
Yes, it is deemed to be from the original date of grant,
Let us see
but
the
then
text of.
there is a hiatus in between.
because they had granted me a notification.
So which rule?
Kindly
18.
see. Relevant rule. 8A, 882, my lord.
8. Yes, capital.
That came in 2023.
A.
882, my lord.
882. All the quarrying leases.
All the quarrying leases or licenses granted before the commencement of the Karnataka Minor Mineral Concession Amendment Rules of 2016 shall be deemed to have been granted for a period of 50 years in respect of specified minor minerals and for a period of 30 years in respect of non-specified minor minerals from the date of its original grant, subject to establishment of mineral availability and workability of the quarry, and also subject to the condition that all the terms and conditions, etc., have been complied with. So, my lord, there is no dispute on this aspect.
Extending,
we
like,
have-
extending like anything.
Even expired leases also stand.
No.
Any
Rule
legal opinion?
8A8 may kindly be seen. Huh? 8A8 in the same
8A8.
The provisions of this rule, notwithstanding anything contained therein, shall not apply to a quarry lease or license or mining lease or of minerals now classified as minor mineral with a notification so and so, so and so, for which renewal has been rejected or which has been determined or lapsed. Therefore, here is a case, blood, this is lapsed, this is a lapsed lease.
Those which have lapsed or which have stood determined by the efflux of time, they are not within the contemplation of clause for renewal is your contention.
Please.
Yes.
Your interpretation is rule 8. 8A8.
88, rule 8K8.
So rule 8A2 read with rule
That's still-
8A8
Yes.
contemplates that the extension will apply to the existing lease zone.
That's.
My case is,
That is their contention.
yes, my case is it has not lapsed. They have given me, it has not lapsed. They have given me a grant. Grant is the main thing, my lord. Execution is a ministerial act. Now what happens is, as per rule 18, which I read, my lord, further time extended, such time as extended by the competent authority. It could be either by necessary or express, or it could be by implication. The fact of the matter
Implication
here is,
also.
my lord, kindly read rule 18.3. Let me read once again the old rules, my lord. Old rules, 18. Such further time. When a quarry lease is granted under rule 11,
Yeah.
may I with the leave of the court?
Yes.
Lease deed shall be got executed in Form E by the grantee within 3 months of the order granting or renewing the lease, or within such further period as the competent authority may allow in this behalf, and if no such lease deed is executed within the aforesaid period, the order granting or renewing the lease shall be deemed to have been revoked. So, my lord, it can be either by an express order or by a necessary implication in the sense by conduct of the department.
Any judgment to that effect?
My lord, in this effect,
24, huh?
in this effect, may I also show to your lordship rule 9?
Rule 9.
Yes. In the same 94 rules. Six ಅಲ್ಲಿ ಇದೆಯಲ್ಲ ಮತ್ತೆಗೆ ಹಳೆ ರೂಲ್ಸ್ 9(2) your lordship. May I read 9(2)?
Rule 9.
Rule 9(2) of the 94 rules.
Yes.
Lord, originally 69 rules were there. They were repealed and 94 rules came. My lords are aware of that. 9(2). An application for renewal of a quarrying lease to quarry specified mine and mineral belonging to the state government, which has not been notified under 8B, shall be in Form R and shall be made to the director at least 90 days before the expiry of the lease. The application shall be accompanied by a fee of, my lord, all that is given. To A, may I request your lordship to read?
An application for renewal.
If an application for renewal of a quarrying lease made within the time referred to in sub-rule 2 is not disposed of by the state government before the date of expiry of the lease, the period of that lease shall be deemed to have been extended by a further period till the state government passes orders thereon. There is an obligation, my lord, for them to pass an order of renewal or rejection. Nothing of that kind has happened. When rule 9(2) read with 18, my lord, there is a discretion to extend. My respectful submission at the cost of repetition is that it can be by an express order or by their conduct, impliedly what they have done. Now, my lord, in this context, sorry.
I have a small doubt about your
Yes.
the jurisprudential acceptability of the contention. Kindly come to 9. You have read 9(2).
Yes.
9(2) is confined to renewal factor.
Yes.
18(1) is confined to the grant itself.
No.
Yes. And the courts have differentiated between grant and renewal. Nagappa versus state, which I had argued.
9 will apply. Basically, my lord, 9 will apply. My lords, I bow down to your lordship's observation.
Now,
9 is a case of renewal.
let us see from a different angle. 9(2) contemplates that the application for renewal shall have to be made 12 months before the expiry of the lease.
3 months before.
Before expiry, 12 months before the expiry of the lease.
Yes.
And 2A says that unless it is disposed of by the state government before the date of expiry.
Yes.
So it is the 1 year's period preceding the date of expiry, which is available for the purpose of renewal.
Yes.
So there is no further, it doesn't go live any further. It doesn't remain live any further.
No, period gets automatically extended.
How?
Till they execute a lease deed, as per 9(2, my lord.
How can we read that? From where we read that?
A further period.
My lord, this, why I am reading,
It's not disposed of the state government. Further period till the date.
Till orders are made.
this,
Here orders are made.
Renewal application was filed on 31/3/2008,
That was after the,
prior to the notification. And we have decided the renewal application, notification was issued. In the notification, that condition was imposed. 18(1) notification was issued. So going back to Rule 9 does not arise.
because 18(1)
It is culminated in a notification, by issuance of a notification, grant notification.
What was the notification?
Last may kindly peruse the page number 100.
No, what was the notification in the sense, because that is important. Was
Notification
it rejection of the application?
granting him quarry lease subject to production of certain documents within a period of 3 months, failing which this notification is deemed to have been revoked
They
by
did not-
virtue of 81.
They did not produce.
That is not produced.
How much
Now,
time they took?
3 months. By a subsequent amendment in the year 2013, that has been extended to 6 months
For production.
for production.
But what control he will have over the authorities who entertain
Exactly.
their application?
But that is the rule. Because they'll take their own sweet time holding the area. See, we have to get the royalty.
Not their sweet time. The sweet time of the other authority.
No, they are-
Over which he will not have the control.
In that event, they have to file an application before the competent authority. Look here, immediately thereafter, I made an application seeking all this requirement, but the authority is not granting. Give me extension under, there is a provision.
Extension provision is.
Provision is there. They have not sought for extension.
Which is that provision?
18 sub rule 2.
is it 94 rules?
Yes.
Oldest, original rules or amended rule?
Original rules only.
Loans, right.
In the 18(1) itself, 18(1). Last may kindly appreciate. May I read?
Old rules? Old. One.
Old rules
That is grant.
or renewal, both are mentioned.
Grant or renewal.
Last sentence.
Execution of quarry lease or quarry license or prospecting license, so and so. When a quarry lease or quarry license of
Renewal is
prospecting license or composite license is granted, the quarry lease, quarry license, prospecting license or composite license shall be got executed in Form E by the grantee within 3 months earlier, my lord. Subsequent amendment is 6 months of the order granting or renewing the lease or within such further period as the competent authority may allow. In the event, Lord, the lessee requests.
He should make an application.
He should
saying
make
that
an-
I have applied for those certificates. It will take its own time, therefore give us extension
Yeah.
that way.
In this behalf, and if no such lease period is, lease deed is executed within the aforesaid period, the order granting or renewing the lease shall be deemed to have been revoked. By operation of this blood, this notification has been revoked.
So this you are correlating with what? Huh? You are correlating this provision with which?
With the notification. Notification.
Notification. Let us see.
Notification is at not page number 101 is the English translation.
So that is under old.
This is for what purpose?
So far as lapsing is concerned, Lord, it is covered by the judgment of this honorable court. I shall predict. 8A8.
So here in this notification, some time period is specified?
Yes, Lord. Within 3 months.
Where
Lord.
is that?
18 itself said that.
18 years,
Itself
but in
says.
this notification, page 101. Did you say that this is to be?
Point K,
3 months time.
Yes.
page 102, point K.
K.
Is that what you are referring to?
Yes. 102 point.
This is contrary to 18.
So it contemplates. So what is the judgment about lapsing?
Lapsing, Lord, if it is a last lease, 8A2, deemed extension can't be.
No, Mr. Rao's contention is, if it is lapsed, well and good. His case is it has not lapsed at all. That is his contention.
But I am demonstrating, Lord, by.
That is your contention.
Statement you are referring to.
Sorry,
Statement relevant paragraph. This is work statement. Copies. Copies. Similar provision.
So according to you, 18.3 notification is relatable to 18.3, which granted renewal subject to compliances. That compliance having not been done within the prescribed period, the rescinding takes place by operation of law.
Yes.
Eighteen.
18.1 itself it is there, not.
That's what operation of law is 18.1.
18.
This does not dispense the quarrying.
Yes. Now I have shown 9(2)(a). I have shown 18, my lord. Competent authority has got the power to extend. No, my lord, what they have done, as my lord, Honorable Justice Dixit Saab has said, that it is in their hands. I make the necessary application. If they take time, my lord, I should not be penalized. No one can take advantage of his own wrong. I'll develop on that, my lord, within 5 minutes. Now, my lord, if your lordship could see Rule 6, my lord, of the old rules. Yes. Rule 6 may kindly be seen, my lord. The legislative intent is made very clear in this. Where the holder of a quarrying lease or a quarrying license fails to undertake quarrying operations for a period of 1 year after the date of execution of the lease or date of grant or license having commenced the quarrying operation, has discontinued the same for a period of 1 year, the quarrying lease or license shall lapse on the last day of the period, provided that the competent authority may, on an application made by the holder of such lease or license before the expiry, and on being satisfied that the holder of such lease or license could not undertake quarrying operations or continue such operations for reasons beyond his control, make an order that such lease shall not lapse. Now, my lord, the same set of rules in a circumstance after a lease is granted envisages a particular provision that I must apply, and the order shall be passed on my application. Whereas there is no such requirement, my lord, as far as 18(3) is concerned, 18(1) is concerned. It is only that the competent authority may extend time. There is no limitation prescribed on that. That, my lord, I will develop by showing their own conduct. Kindly see 2 documents. What they have done. At 104, my lord, annexure F.
It will be double-edged knife to you, that argument.
Yes, this is all loud thinking.
Yes, yes.
Nothing more, yes.
I know, my lord, discussions only will bring out the best.
Yes.
Rule 6, my lord, as your lordships have seen, it is a case a lease is granted or a quarrying lease deed is executed, you start and stop for a period of 1 year, or you don't start at all for a period of 1 year. then you have to apply for extension to avoid lapsing. That comes after a lease deed is executed and working does not take place. Whereas this is prior to execution of the lease deed, where there is no such requirement. All that I am trying to say is, if the legislature intended that even in case of Milord 18, I need to apply, they would have said that. They have not said so in one prior to execution of the lease deed, said so after execution of lease deed. The intention of the legislature or rule-making authority is very clear that competent authority has got power to extend as much as it can, Milord, is one thing. That is coupled by the fact that after a period of 3 months, as per Annexure F, page 104, they have given me an environmental impact assessment clearance.
That is given by
That is given by the environmental,
some other
state level
department,
environmental impact
Government
assessment
of India.
authority.
some other entity,
It's a state entity.
Union of India.
Union
All
of
the
India.
state level.
Union of India has given that
State level
authority under another legislation.
State authority.
It is under the Environmental Protection Act. Under the ministry, state has been given power, state level authority.
We'll process that, but just give us some foundational facts.
Yes.
We'll invoke your argument.
Yes.
When you had applied for those certificates and documents, which date and which date they were given to you?
Yes, two things I can mention, my lord. Out of the two requirements, major requirements, your lordship will see, I will get the date, my lord, I will show the document to avoid.
26/7/2012, they have applied for environmental clearance.
26/7/2012.
12.
When that
Notification was issued on 21/2/2012. That is after lapse of
5 months.
The requirement is within 3 months they have to.
Application itself is after 5 months.
And conversion application was also filed. That was also granted by them.
When conversion application was filed, when it was granted?
11/1/2011. They granted me on 4/4/2017. Pursuant to an order of the courts.
If they granted you on?
4/4/2017, document annexure J.
Section 95 order.
Yes. Prior to that, pardon me for bringing back to your law, this 111, they have also collected environmental impact assessment was granted and environmental protection fee was collected from me.
But you applied it on 26/7/2012.
Yes.
By that time, the period prescribed, had you applied it at least within 3 months, saying, I have already applied, I have no control over the authority, therefore please wait.
Yes.
We'd have understood.
As far as environmental, there is a 2 months thereafter.
Yes.
But as far as this conversion, it was applied in time, they took 6 years. Another document for your lordship, 113 million. It's an order of this honorable court. Wherein, my lord, the petitioner, original petitioner, my father had died and I represented him. and sought, my lord, for a prayer to declare that Rule 32 of the KMMC rules amended is bad in law. But that matter came up for hearing, my lord. Kindly see page 115, 125, sorry.
At the time of deemed extension, you execute a fresh lease or
Yes,
fresh deed also.
we have to.
So that things do not go unregulated.
Even stamp duty is payable for
Yes,
that.
yes, yes,
Yes.
Now kindly
Agreeance
see,
has to be there, stamp duty has to be there.
Kind of.
kindly see page 125. May I read that?
Yes.
The office objections are overruled. Issue notice to the respondents. 125, my lord. My lord, the Honorable Chief Justice.
Yes.
Mr. V.G. Bhanu Prakash, learned additional government advocate, accepts notice for all the respondents. Therefore, formal service of notice to the respondents is dispensed with. By consent of the learned advocates appearing for the parties, the writ petitions are taken up for preliminary hearing. On instructions, Mr. Lakshmaya, learned advocate appearing for the petitioner, submits that he is not pressing the prayer for striking down the amendment carried out to Rule 32 of the rules. The writ petitioner is a patta holder from Old Bombay area. Lord, according to law, he is the owner of the mineral himself in Old Bombay area and Old Mysore area. Unlike Milord in Old Hyderabad area or Old Madras area, they are different. Now, Milord, kindly see the next page. The writ petitioner is a patta holder inter alia of 2.20 acres of land in a private patta land in survey number so and so, Bagalkot district. It is an admitted position that conversion of the land for commencement purposes has been permitted by the order dated April 4th, 2017. The environment clearance certificate has also been granted in favor of the petitioner on December 4th. The writ petitioner, however, cannot start quarrying operations for extraction of pink granite because of non-availability of the working permission. Because he is a patta holder, my lord, he has to only get working permission. The writ petitioner is a patta holder. There has been permission to convert the land for commercial use. Environmental clearance is also obtained. Therefore, we dispose of these writ petitions by granting liberty to the writ petitioner to make a request for working permission to extract pink granite from his patta land by 1 week. If such an application is made, the authorities are directed to issue the work permission within a period of so and so. My humble submission here is, in this case, two things, my lord, emanate. One is I am a pattadar, admittedly. Number two, my lord, when this matter came up, the state government did not plead or take a stand that your renewal has already lapsed. Question of granting any relief to you does not arise at all. No such stand was taken. On the other hand, by consent it is stated, if I apply for a working permission within, my lord, 1 week, they shall consider and grant. But however, my lord, when I applied, they have not granted till now. That is the situation. Now my humble...
Positive or case before the court that renewal has been done.
My case here is renewal notification is issued, but I am a pattadar. So I have a right to extract. I had challenged the validity of Rule 32, which required, my lord, for us to obtain a license. That was granted, my lord, to us by the notification. Now, my lord, in this case, after so many years also, the state did not, or its instrumentality did not take a stand that my lease has already lapsed. Question of granting any relief to you does not arise at all. I am made to believe I should apply and they will consider and grant me. There is a specific direction to grant working permission. This is the order of this honorable court. Notwithstanding all this, if your lordship would kindly see 2000, that deemed extension rule once again. And Patadar has to take a license, my lord, as per rule 32. It's not a lease as such it is called, but it is shown as license. Deemed extension, my lord, pardon me if I have to repeat. Rule 8A. Sub-rule 2, no? Sub-rule 2 may kindly be seen. Yeah. Yes, produced inside. My lords have that rule. 8A2. All the quarrying lease or license granted before, kindly see this, my lord. Leases or licenses granted before the commencement of the Karnataka Minor Mineral Concession Amendment Rules of 2016. I was granted in 1998. Shall be deemed to have been granted for a period of 50 years in respect of specified minor minerals. Mine is a specified minor mineral being pink granite. And for a period of 30 years in respect of non-specified minor minerals like sand, building stone, etc. From the date of the original grant, subject to establishment of availability of mineral, etc. There is a deeming provision that it gets automatically extended for 50 years. That is the judgment of a coordinate bench of this honorable court, where it is said statutorily it stands deemed extended from the date of original grant for a period of 50 years. I have not got those judgments. I can pass it on for your lordship's kind consideration.
Unless case travels to sub-rule 8. Unless case travels to sub-rule 8.
Notwithstanding any one of these, sub-rule 8, my lord, yes. Before that, my lord, 8A2 categorically says it stands extended for a period of 50 years. If it gets extended for a period of 50 years from the date of original grant, it is an automatic extension to me. Is the coordinate bench which has taken that view, my lord. I will pass on those judgments for your lordship's.
The question, even where lease has lapsed because of sub-rule 8.
Yes.
Even then extension will happen.
Not
Is
a
it the
case
risk?
of-
Not like that.
Not a case of cancellation or revocation. Otherwise, my lord, renewal applications pending, and where, my lord, the authorities are still considering, in such cases, my lord. But this is, my lord, judgment of a coordinate bench. Page 46 of that. You got the copy?
Yes.
Page 46. This is for major minerals, identical rule, my lord. This is where my, if I'm not mistaken, additional advantage for the state. Kindly see, my lord, the relevant page. Page 68, my lord. Ink page 68. In the previous page, the learned judges have quoted that rule extensively. And they have also stated, my lord, page 66, rule 8A, section 8A. This is regarding major minerals, iron ore, my lord. Similar provision. Now kindly come down to, my lord, next page. At the bottom, May I read with the leave of the court? Last 5 sentences. In both the cases in hand, the period of 50 years from the date of grant of a lease expired prior to 31st March 2020. Even the period of renewal made earlier expired before 31st March.
No,
I'm sorry, my lord. Ink page 68. Type to page 23 of that judgment. Ink page 68, my lord. 68. 68.
Type to page 23.
Sorry, my lord.
Running that print page.
Yes, yes,
23.
yes. Ink page is running page of all these citations.
So in the present case, where you are reading, starting from where?
In both the cases in hand, last 5-6 lines, my lord. Page 68.
Yes.
In both the cases in hand, the period of 50 years from the date of grant of lease expired prior to 31st of March 2020. Even the period of renewal made earlier expired before 31st March 2020. That is how the petitioners are entitled to the benefit of deemed extension of lease up to the period ending to 31st March 2020. Therefore, by a legal fiction, under subsection 6 of 80A of the said Act of 57, in these cases, leases stood extended up to 31st March wherever subsection 5 or subsection 6 of 8A of the said Act is applicable. There is an automatic extension of the lease as on 12th January 2015 up to the period specified in subsections 5 or 6, as the case may be. The phraseology used in both the section is shall be extended and deemed to have been extended. Therefore, the deemed extension of lease takes place automatically on 12th of January 2015 when section 8A was brought on the statute book, and no event can stop the deemed extension. I had appeared in this case. What happened was, my lord, by the time I could get that deemed extension also under these rules, sections, the period, my lord, also had expired. I said, at least permit me, give me that extension period. But the court said, my lord, you have to go to the civil court only for damages for not permitting me to work those days. From the labs and so there is, my lord, automatically it is deemed to have been granted for 50 years from the date of original grant. Now, 88, which my learned friend relied upon, speaks of for which renewal has been rejected or which has been determined or lapsed. This is not a case of lapsing. Lapsing comes under Rule 6, my lords have seen. This is a case of, my lord, a revocation according to the rule. It makes a lot of difference. Determination.
Determination, lapse, termination, rescinding.
Listen.
These are all legal concepts.
Concepts having different meanings and connotations. So my contention is 88 does not apply as taken by my learned friend, my lord. Next, my lord. Yes. Now, my lord, apart from this, my second point, which I said I have only two contentions or prayers. My lord, they have inspected according to them my quarry. 2014. Kindly go to page. Annexure. N. Kindly see page 145, 147, my lord, annexure N. My lords have annexed page 147. In page 147 of the writ petition.
Mixer N.
No, my lord, here, if your lordship would give
Audit report.
audit report. My lord has had an occasion, my lord, where this is done without opportunity. My lords are pleased to set aside and send it back, coordinate bench of this court, to which my lord Honorable Justice Dixit was a party to that judgment. Now, my lord, the grant in my favor and renewal notification is for 2 acres. Here, my lord, kindly look at the audit report at page 148, 149 is the translation. Kindly have a look at
47 is translation.
my lord, I have given 147 translation. Audit report is at 149. Accompanying audit report. 149 ink page, my lord, annexure N. My lords have that. At the top, my lord, area granted is according to them 6 acres and 6.02 acres. My original grant itself is for 2 acres, 2.20 acres. He takes it that I have been granted 6.02. That shows what is the nature of application. This audit report, my lord, they fall back on an inspection of 2014. After I gave a request for deemed extension, they come up with this, my lord, as a counterblast. Annexure M I had requested for deemed extension. This is thereafter. 3 months after that. Kindly take, my lord, I don't want, nor do I request this honorable court to go into nitty-gritties of mathematics, calculations, etc. On the face of it, I will show how, my lord, this is wholly without jurisdiction and wholly illegal. Kindly see, my lord, in this details of royalty, demand, fixed rent, etc. First, my lord, 2014-15, your lordship gets it. All these columns up to 2017-18, production is nil. My lords get that. Then he makes a demand and the production is nil. Kindly go to annexure 4 of the document, page 150, my lord. I'm sorry if I'm taking too much of your lordship's time.
No.
But
Not at all. Yes.
yes, page 150. In the previous page, he says there is no production. In this, kindly see, my lord, 14, 15, 16, 17, 17, 18. For the months, there is a demand and interest on that. When there is no production or dispatch, he calculates royalty, and then on that, my lord, he, my lord, calculates interest on that. This is on the face of it, my lord, is not sustainable. I don't want that figures to be looked into. Only thing is that they have made a demand. In the previous page, in the same document, he says, look, for these years, there is no production. Next page, he calculates royalty, interest, and a heavy sum of 72 lakhs, etc. is demanded on me. This was done, my lord, without even an opportunity to me. There are two things, my lord. One is inspection. After inspection, my lord, they will calculate according to them and then send me a first notice. Then I will get an opportunity to meet that. Thereafter, they should come to a conclusion and make a demand. In this case, what happened was in 2014, they inspected, they said nothing about the working outside, etc. details. Interdepartmentally, they say this is the extent of material which is illegally removed and make a demand. I'll just show this, my lord, on this content. And the amount here is 72 lakhs, as your lordships have seen, at 150. Audit report, which is, you know, highly bloated, which should have been 0, but they have said like this. Annexure F, my lord, PP 152. Kindly see page 152, Annexure F, my lord. Annexure P, my apologies. P.
13th November.
Yes. To the Deputy Director, Department of Mines and Geology, 13th November of 2019. With reference to the above, what is the subject? Extension. City so and so, wide letter and a reference has requested for extension of QL for a period of 30 years. At that time, first amendment was 30 years. So and so. Therefore, with regard to extension of quarry lease period of 30 years, as per Rule 80A of the Karnataka rules, it is hereby informed to submit the information to the points mentioned in block list enclosed to this letter along with clear recommendation report.
Where is that block list?
Which one? Block list, my lord, they will ask a forum and then he will fill it up and give it to them. It's only all that I am showing this is that the department is actively considering my request for deemed extension. They never raised that lapsing, my lord, in the earlier judgment.
Who grants extension of the lease? Who grants actually?
The competent authority.
Who is that?
Who is the Director of Mines and Geology?
But this letter is by Deputy Director.
Because of two different regions. He is asking for information from Bagalkot. This is my lord Deputy Director in the head office. If your lordship would see at the top, Khanija Bhavan, Racecourse Road, Bangalore. He is asking the Bagalkot Deputy Director to give these particulars. And after that, they will place before the Director. Then, my lord, Annexure Q, not necessary. Same thing. Yes. Annexure, yeah, yes. QRS, R. Page 155 is the Kannada version. Translated version, my lord, is at Annexure R, page 158, English translation. This is given in the name of my father who's dead. I had applied for to include me as a legal heir, but nevertheless it is given in the name of my father. If your lordship would kindly see this. Kindly come to 181. Again, my lord, for 1920 production here is 0, but demand of royalty is 9,37,000. and balance of 72 lakhs he carries over. And interest is levied again on this. Now, my lord, I will show only two documents filed along with the statement of objections, just to show, my lord, how, I don't know whether I am entitled to use the word, the department is misstating the facts. I don't want to go a little further up. So I will stop there for personal and ethical reasons. First, you have to- Yes, Nazar is in Kannada. Translation. You know, page 19 of the statement of objections filed by the state, my lord. On behalf of all the respondents, it is mentioned.
Mahajan.
Page 19.
Is it Mahajan?
Mazar. Kindly see at the top, my lord. Letter dated 25/11, my lord. They make a joint survey according to them, inspection on 5/12/2014 at 2:30 p.m. My lord, I have signed this inspection report. Praveen H. Hulageri, your lordship gets at the bottom as the legal heir of my father, the original grantee. Joint survey has been taken up, etc. This does not contain any allegation against me, subject to correction by my learned friend. And this says, my lord, they have surveyed and took the measurements. Based on this, my lord, based on this, my lord, page 16, he has filed an amendment, translated copy, my lord, which says that there is an encroachment, there is removal of so much of granite from this area, etc. It is an interdepartmental communications to which I am neither a signatory nor any opportunity is given to me to counter, my lord, the conclusions which they have arrived at. So much of allegation, my lord, it's interdepartmentally done, or within the department, I should say, intra. Then I go to Annexure R3 page. To the next document. Have a look at their statement of objections. Para 11, my lord, typed page 8. May I request your lordships to see their statement of objections? Page 8, para 11. Last 6 lines, my lord, at the bottom. Further, my lords get that?
He submitted that.
Yeah. Starting there, yes, my lord. Last 6 lines. My lord, the Honorable Chief Justice got it. Page 8, para 11 of the statement of objections.
Page 8.
Further,
He submitted that.
Further, the petitioner, before it starts from it is submitted,
In that state, they don't call it a statement of objections.
oh, I'm sorry, my
And
apologies.
we have the system of running pages, so please.
Yes, my lord, normally that helps. continuity of.
So I'll get accustomed within a
But
10
in,
days.
what has happened in this
Getting
court
it
is, if my memory
nearer to
serves
it,
me
yes.
right, in writ appeals, my lord, there is a continuity of page numbers, there is a
Hearing.
circular to that effect from the registry. I don't know how much of it is followed. But further, the petitioner,
Yes, it is submitted.
I'm curious to know what is it called, my lord. In Gujarat, what is it called, my lord?
They have running pages.
Running pages.
Yes.
Further, the petitioner before to this audit report wrote a letter on 2/2 to respondent number 4 to consider the earlier penalty imposed of 72 lakhs 31,000 to him and requested to forgive his mistake in providing the information during the audit time. The copy of the letter dated so and so is at annexure R3. My lord, this a statement is made on oath that I have written such a letter. My lord gets that. Now kindly permit me to refer to R3, my lord. What page? Yes. 25, my lord, page, it is in Kannada language. It is a letter written by the senior geologist and not me. He says he has made a mistake. It was 72 lakhs. He has brought it down to, my lord, 22 lakhs and odd. So he has made a mistake and says in future he will not do such things. It's again, my lord, a misstatement of fact. Their own document reveals this. At the bottom, your lordship will see geologist.
Bottom, yours faithfully.
Sorry, my lord.
It is only yours faithfully.
Not my statement. It is signed by the senior geologist alone. I have not signed this, nor is it my letter. Translation is wrong, my lord. It's not yours faithfully. Kindly see the Kannada version. Senior geologist signature. He writes there, geologist. Page 21 and this page signature, if your lordship would just with a naked eye can say it is the same geologist. He writes.
To whom he writes?
He makes a, my lord, a report to that effect in the file.
To whom?
It's not mentioned. They don't say anything on this. Produced by them.
But generally, Tamma Vishwasi is yours faithfully.
Faithfully addressed to somebody. But he himself, my lord, the respondents have produced this document.
You cannot be because place 27.
Yes.
From the joint, it is found that Sri Hanuman Sulgiri, that is petitioner. If it were to be yours, you would have said it in first person, not in third person.
And this is signed by senior geologist, not me. But in the statement of objections, it is stated as if I have admitted that I have committed a blunder. It's the other way around.
At that time, his father, not son, is right.
Assuming that father, how he will say that name?
Father signature.
Father, the lease was executed in the name of father. He died. Subsequently, son writes this letter.
Lord, this is not signed by me at all. How can he say either my father or I have signed this? Geologist signature, this is his document. It's not that I have produced it.
And why he will apologize for the mistake? Where is the mistake? Read the last paragraph. We are only on recovery amount. We are not on other aspects. The particular point is being urged now.
Yes, yes.
Our conversation is confined to that one. Not renewal, etc. is not the point. How he will apologize? Some officer is saying that particular things I could not see by inadvertence, kantappinindagi. By inadvertence, it has happened like this, I may be pardoned. Hereafter, I will not do that mistake. Appears to be what officials will say to the higher-ups when they err.
Page 21, signature is identical.
Same
Same
deputy
geologist,
director.
same person. Just a naked eye, my lord, page 21 bottom and page 25 bottom.
I'll clarify this. There are two inspections done. One is in the year 2014 and another is in the year 2022.
No, so far as this is concerned.
Yes, there are two penalties imposed.
Correct.
One is 72 lakhs 31,242.
Correct.
As well as for illegal encroachment and extraction of mineral.
22 lakh 25,960. Correct.
Both are correct.
Both are correct.
Both are correct. Both are correct. Now the present demand is to the tune
He
of.
says, I have not confessed. I have not admitted anything. Without my admission, liability cannot be fastened on me is his contention.
Be that as it may, my lord. The fact remains is as on today, he is liable to pay 99 lakhs as per the present demand.
How you arrived at?
That I may be permitted to submit, I'll make my submission.
Even if this is excluded.
There's no question of exclusion.
No, this letter, he says, I have not given such letter.
There are audit reports to that effect. There are audit reports.
No, that means therefore, we are asking you.
Please, please.
Even if this document is excluded from consideration.
Please.
Still the claim is demonstrable.
Yes,
is your version.
Our claim is not only based on this letter. There are other documents.
The other documents
But that
are,
contention you have taken up at page 8.
Yes, page 8, we have taken up that contention. My instruction are that this is written by the son of the lessee.
kindly have a look at that inspection report. It doesn't say anything about illegal working or what is the extent. Intra-department, they sit and say, this is the extent and this is the demand you pay. Where is the opportunity? Where is the inspection report given to me? Same grounds, my lord, your lordships have quashed. In my compilation, I have shown. Kindly see my compilation.
Of the petitioner only, no, not petitioner, some other.
Some other identical. Kindly see my compilation.
No, I do.
Two of them.
Myself and Honorable Justice, Chief Justice Varalesa.
Yes. And also Honorable Justice Rituraj Avasthi. Both. Page 42 and page 95. I won't read since my lords of the compilation. Case law compilation. Hmm. 42 and 95. And my learned friend himself had appeared in those cases.
Second compilation. No, this.
Case 95, coordinate bench judgments both, and 42.
We only, I remember, we have only remitted the matter for fresh consideration.
Giving
after
me an
notice to you.
Opportunity to
That
meet
is a
this
case
demand.
wherein Lord, he was not present.
In this case, he has participated.
He participated, videographed, photographed, everything is there.
But that Mazar doesn't say even one word about illegal working or the extent. How did they come to that conclusion to make a demand? Should I not get an opportunity to meet that? prayers, I am requesting statutorily deemed extension of my lease for a period of 50 years from the date of original grant, irrespective of the situation, as if it is granted for 50 years. Whether it had expired, etc., does not arise, unless it is, as my lords had observed, revoked, determined, not revoked, determined, or lapsed. Therefore, resigned. Therefore, that is first prayer, my lord, automatic deemed extension. Number two, my lord, quash these demand notices, give me an opportunity. I will appear before them and then let them come to some conclusion. These demands are made without even a chance to. That's all my respectful submission, my lord. Obliged.
Last, may kindly see. The challenge in this petition is to the notice demanding rupees 72 lakhs as per annexure N of the year 2019. Challenged in the year 2022. So far as blood demand made in annexure N is concerned, the quantification was done way back with this 14 itself. 14 itself, then this petitioner was not there, his father was there. And he was present. This petitioner was present during the time of Mahajar. And blood, a quantification was done. That has not been challenged by the petitioner for 10 long years. Demand every year, Lord, every year we send audit reports to the lessee. Yes. No, we issue notices, not audit report in the form of demand only. In the form of demand only, every year we issue. Lord, before that, I would like to draw your lordship's kind attention to 1810, please. Rule 1810. Because this is very relevant. In every case, Lord, lessee, whenever the demand is made, they came in challenging the audit report, simpliciter. It is like challenging the IT returns, IT demand. Whenever the income tax department demands tax without challenging assessment order, I will not furnish any particular to the income tax department. They will not pass an assessment order demanding certain amount. Now I make rule 1810. Rule sub-rule 10, quarterly returns, yearly returns for each financial year before the 10th of April of succeeding year. Such report shall furnish specific information on the quantity of minor mineral and the waste rocks produced, this is a mandatory requirement. The person alleging that I have not been heard, he shall come up with all this document, produce before the court. Look here, I have maintained all the statute, the books of account. Yes. Yes. Not prior to that. See, these are all the areas of royalty, dead rent. These are all arrears of royalty dead rent. Your lordship may kindly peruse and I shall, Lord, annexure N. The lordship may kindly peruse the audit report produced at 146, page number 146. After 2012, that is exactly for the reason, Lord, in Anubandha 1, that is Schedule 1, for 14-15, zero production was shown. So on and so forth. Even in Annexure 2 also, there, Lord, we charge stira, the dead rent. Dead rent as per last but one column. Yes. Yes. Lord, we have conducted the inspection in the year 2014. Then we found that he has illegally extracted, encroaching upon the beyond the area of the lease. That is why we have imposed penalty to the tune of rupees 72 lakhs, which he has not questioned. That is the margin, Lord, which as per annexure R1. Yes. That is in the year 2017. Yes. Please. This is penalty only. Penalty for illegal extraction. Yes. No, there's no such demand. Please. Yes. Please. Yes. Please. Please. Yes. May I draw your lordship's kind attention to para 8 and 9 in my statement of objections. Para 9. The respondent number 4 here in verified records pertaining to quarry lease number 255. Lordship got it. Statement of objection. Yes. Yes. That is like illegal quarrying outside the lease. Outside the area. Not the grant. Hence we write production is 0 in the granted area. 0. That's right. Without there being any license. He is not allowed. Without license, he cannot do it. Even that amounts to illegal mining only. We have not allowed, my lord. He has conducted. He has conducted without our notice. Last week. Para 9. Para 9. Yes, adjoining to the lease area was encroached and worked area in hard granite extent of 0 so and so, depth is so and so, and 350 metric ton was illegally extracted. Then thereafter, my lord, this is in the year 2014. Inspection was conducted on 5/12/2014. Thereafter, my lord, yes, yes. Mahajar is there. In his presence, it was conducted. And it was recorded in the it was videographed and photographed. Was stored in CD and photos also taken at the time of conducting Malta. And that of our lord, he has extracted 355 cubic meters of granite. Penalty amount for 1065 metric ton was computed at 5 times. It comes to 22,25,960 as per annexure R2. But immediately after this plan, that yes, yes, we have raised the demand immediately because my instructions are not every year audit report. These demands will be there. That is mandatory. Even for a last lease, expired lease, even for 2023, for the very same lease, we have issued notice demanding 98 lakh 32,364. Please.
November 2023.
Yes, yes.
Then how can you say that it's time barred?
Which one is time?
Your contention is that demand which now he is challenging, that he has to pay, and now he cannot challenge it is time barred, it being time barred. To demonstrate that, you have to show, based upon the audit report, we have raised the demand by issuing notice way back in 2014, 15, 16, 17, maybe 18 also. But he did not do anything. Now all of a sudden he has knocked at the doors of the court. If that is your stand, you have to demonstrate from records that you had raised the demand. Because the apex court has taken the view where challenge is to the demand. After you issue notice, the cause of action becomes coherent. These are the words of the judgment itself.
My submission was, though this was quantified in the year 2014, thereafter demand was made.
We are asking first demand, when did you do?
That demand notice we have not produced.
Ask your officer is producing 2023 notice. Ask him whether any notice earlier given is available.
So your ground of challenge belatedly can hold, provided you can show that the demand was
made,
raised at the earlier point of.
Even be that as it may, Lord, even that is not considered. The fact remains is, Lord, he is liable to pay the 98 lakhs as on today. That is one aspect of the matter. So far as Lord 8A8 is concerned, that is clear, Lord, because under 8A1, 18.1, even if he had approached the authority for extension of the time, The authorities could have extended only for 3 months. For such a period, the word used is,
Why 3 months?
because the word used in 18:1, your last may kindly appreciate. For such a period.
Under the old rule 18:1.
Yes, yes.
No, such a further period it is. It does not say further period of 3 months.
No, no, not.
Further period means in addition to 3 months.
May I read, Lord?
Yes.
Competent authority may allow in this behalf, and if no such lease deed is executed within this aforesaid period, the order of granting renewal of lease shall deem to have been revoked.
No, you have left one sentence you have jumped.
Yeah, yes, sir.
There is expression, further period.
So you're reading old rule or new?
Old.
Old one.
18:1.
Shall be got executed in me by the grantee
In
within
the aforesaid
3 months
period.
of the order of granting or renewal of lease, or within such further period, within such further period relates back to this plan, the private.
No.
If it is 3 months means.
No, not exceeding 3 months. They would have coined the rule. If you see the pattern of legislations and rule making, there is a pattern available, which C.K. Allen in the Law in the Making discusses about that. If the pattern is available, how the pattern is available? Where you say not exceeding 3 months.
That is not stated.
That is not there. But such rules are there already.
Yes.
Similar pattern rules are available in the book itself.
Please.
But therefore, that pattern you cannot attach to the text of it.
Any view of the matter, Lord, they have not made any attempt
within the
stipulated period. Now they cannot contend. So far as 8A6, Lord, the learned senior read in page 66 of the compilation. That is not applicable. Because they were dealing with 8A6. 8A6 is nothing to do with 8A2. Last may kindly appreciate page number 66 of the compilation.
It, 2016 amendment.
Yes.
16 amendment.
Not in the compilation, page number 66.
Is this. Compilation of judgment.
Yes.
Yes.
The period of prospecting license.
Notwithstanding anything contained in subsection 2, 3 and subsection 4. This begins with the word not. Lord, this is in respect of major mineral. MMDR Act.
The Act.
MMDR Act. It is in the compilation produced by the other side, which reads as, notwithstanding anything contained in subsection 2, 3 and subsection 4. They are relying on subsection 2. The period of lease granted before the date of commencement of the Mines and Mineral Development and Regulation Amendment Act 2015, where mineral is used for other than captive purpose, shall be extended and be deemed to have been extended up to a period ending 31st March 2020. Here that 30 years or 50 not there. This is for the existing mines. This provision was provided. With effect from the date of expiry. This came into effect from 12/1/2015. With effect from the date of expiry of the period of renewal last made or till the completion of renewal period, if any, or a period of 50 years from the date of grant of such lease. Suppose, Lord, 12/1/2000 in the year 2014. A lease is granted for a period of 10 years. Then, Lord, that is in currency. In such cases, from the date of inception, from the date of
That
initial lease
50-year period to be
50
computed from the date of the grant of lease itself. Is it?
Itself is the purport of this section. Therefore, this is not applicable to the facts and circumstances of the case. Therefore, my lord, and one more aspect of the matter, my lord, even assuming for a minute that they are entitled for deemed extension. And then in common cause case, the Honorable Apex Court clearly
Which year common, there are many common cause
yes,
cases.
my lord, which I have produced along with the statement of objections and as annexure R4. Page 51, para 31.
There are 30.
31.
31.
Irrespective of the position noticed herein above, it is imperative for us to clarify that the benefit of extension of lease period past. I'm sorry.
Yes.
Irrespective of the position noticed above, it is imperative for us to clarify that the benefit of extension of lease period stipulated under 8A, Section 8A of MMDR Act is available subject to further overriding conditions, namely
All
the terms and conditions of the lease have been complied with. A leaseholder who does not satisfy any of the required condition of the lease, as for instance, the postulated clearance approvals consent would not be entitled to benefit of extension under subsection 5 or subsection 6 of 8A of the amended.
So same interpretation has to be placed on the 18 rule 18, which provides for 18(1).
18(1). Now may I take your lordships to the lease deed which earlier lease deed which we have executed. Page number 58 of the petition, please. Course of action if the rents and royalties are not paid in time. Page number 58 of the petition. Middle. 3. Under part 4. Should the royalty and or rent reserved and made payable by the lessee, licensee is not paid within 30 days of the date fixed in lease or license for payment of own, state government may enter upon the premises and restrain all or any of the mineral or beneficiate, proceed of operation movable property there and may order the sale of property to restrained or so much of it as it will suffice to the satisfaction of the rent and royalty due and all costs and expenses occasioned by the non-payment thereof. 3A. If the lessee or licensee makes any default in payment of royalty or dead rent payable under Rule 26, the competent authority shall give notice to such lessee or licensee requiring him to pay the royalty or dead rent within 60 days from the date of receipt of the notice, failing which the competent authority may, without prejudice to any other action that may be taken against the lessee or licensee, the lease or license, or forfeit the whole or part of the security deposit. Any rent, royalty, tax fee, penalty, or other sums due to the government under the said rules and under this lease license shall be recovered as arrears of land revenue if on the basis of the certificate issued by the competent authority.
But they contemplate the issuance of demand notice.
Yes. That has been issued.
So both of you would like to give synopsis,
Very well.
written submission?
Please.
Yes,
So when you, within, by Monday?
by Monday.
By
Monday. Third learned senior advocate Mr. D.L.N. Rao, assisted by learned advocate Mr. Aniruddha for the petitioner, and learned government advocate Mr. S.S. Mahendra for the respondent for my at length. Learned advocate paragraph for the respective parties submitted that argued the petition finally. They further stated that the pleadings are over and no further are required to be added or supplemented. Full stop. Next, reserved for judgment.
Grateful.
You need this. Keep this.
For the patient here.
The appeal was called out in the larger interest of justice, put up after 2 weeks. Or say, after reopen, after reopen. Any date of first or second week.
Party urgent, number 41. Bill by government.
Lord, I appear for the appellate. Not in this case. Not the respondents 1 to 3 who were in unauthorized occupation of 5 acres of land. My Lord, they filed an application. My Lord, after following the due process of law, a grant order is issued. My Lord, thereafter, my Lord, there is a complaint that is given by respondent number 4 with regard for cancellation of the grant and the Sagu Ali chit. My Lord, after due process, my Lord, it is found that the complaint was not genuine and so the complaint is rejected. My Lord, then he files a petition, my Lord, seeking for cancellation of the grant, my Lord, under section 108D. On the ground that, my Lord, this 5 acres of land comes within 5 kilometers from the, yes.
Such matters. In the radius of 5 kilometers. You sought for stay.
Lord, I've sought this.
there are other matters.
IA2 of 23.
Delays.
Not delay of 230 days.
Delay is that our learned government advocate, Ms. Neela Doctor, notice to respondents returnable on when shall it?
I leave it to management.
After
After reopening first.
My lord, I appear for the appellant. My lord, the respondent number 1 who was appointed as an associate.
Here also
professor-
delay of 330.
Ma'am,
Notice same.
obliged.
Appear for appellant, madam. Kindly have it on Wednesday, madam. Day after tomorrow,
Delay.
20th. madam. Kindly have it 20th.
You want adjournment?
Yes, please. madam.
Why?
You only have moved it.
Notice.
20th, please. madam.
Notice.
I am for the complaint in this matter, my lord. My lord, Annexure A, case number 10, my lord, order dated 2/3/2023 is not complied, my lord. Wherein, my lord, the Honorable Learned Single Judge directed the respondent authority to appoint the petitioner as a Anganwadi worker, my lord, within 4 weeks, my lord, from the date of receipt of copy. Accordingly, my lord, the petitioner has submitted the request letter, my lord. Though request letter is submitted by the complainant, my lord, the respondent authority is not complied the order dated 2/3/2023.
Notice has to be.
Please, ma'am.
Or
I will do.
after vacation.
I will furnish. Copies.
This side. Okay. Last second or third week of April.
You are for respondent 4.
Your way accepted. Learned government advocate accepts.
Please.
Lords, for the appellant in this matter, I'm led by Senior Counsel Mr. Navadgi in this matter, my lords. Any date may be given. my lord.
Appear for the respondent number 1, my lords.
Senior was here, my lords, now had to leave.
2 weeks. When do you want?
Any date.
What is the subject?
my lord.
What is the subject matter?
My lords, it was regarding the allotment of sites, my lords, to the appellant. With regard to the allotment of sites, a status quo was granted by the
So
son.
what is the subject matter of the appeal?
Not aware.
No, my lords, a site was allotted to the appellant, my lords, in this matter. And the learned single judge has held that she is not entitled to the said site.
Notice will is
Issued, my lords. Status quo was granted by this honorable court on 2nd of Jan 2020.
Huh?
Status quo was also granted, my lords, in this matter.
Your voice is as weak as your case is.
Status quo was
The mic.
granted. Status quo was granted, my lords, on 2nd of Jan 2024 by this honorable court.
issue notice.
Notice was issued, my lords.
My lord, on the 2nd of January, my lord was pleased to pass an order of status quo.
Status quo is there.
Status quo is.
Vacant
So
site
delay is
allotted to.
Delay is called. So our learned advocate is so and so for the applicant in the interim application which prays for condone of delay of 92 days. The evidence in the supporting affidavit makes out a sufficient cause to condone the delay. Delay is condoned.
Please.
The appeal may be listed on 16th of April.
Please, my lords.
Order of maintaining status quo granted by order dated, in order dated 2/1/24 shall continue to operate.
Please, my lords. Grateful.
My lord, in this matter, petitioner, please. It is the writ petition filed against the respondent number 7, seeking to pursue the annexure X, please. There is a direction given by the higher authority, respondent number 5, to the respondent number 7.
Please read your prayer at page 27.
Please. Direct the respondent number 7, the Panchayat Development Officer, Chikali Gram Panchayat, Chikali, Vainoskota, Obli, Pavgada Taluk, wide annexure X.
What direction?
The respondent number 5, direct the respondent number 7 to take an auction.
To take,
Action.
this prayer doesn't make any sense.
Official memorandum passed by the respondent number
To
5.
make your prayer explicit in terms of what does it convey?
Otherwise, because specifically provides for grievances. We should exclude that.
Remedy under the local.
So public property.
Please.
The short grievance of the petitioner is as to no action being taken by the Panchayat Development Officer for protection of the public property despite giving representations and reminders. First off, the Learned Counsel for the petitioner submits that it is the duty of the local body to protect the public property, and when it fails, this court should come to the aid of the citizen who has invoked the PIL jurisdiction. First, Learned, do you take Panchayat Development Officers? You do not take?
My lord, I take notice for 1, 2, 3.
Learned AGA on request accepting notice for respondent numbers 1, 2, and 3. So opposes the petition.
My lord, 8, 9, 11 to 14.
8, 9, 11 to 14. 8, 9, 11 to
It is a
14.
Panchayat, my lord, of Pavgada.
And Learned Counsel Sri, Panel Counsel Sri A. Nagarajappa appearing for the Panchayat concerned, opposed the petition, contending that grievance of the kind can be worked out by the petitioner by approaching the competent authorities under the provisions of the Karnataka Lokayukta Act 1984, as has been held by this court in WP number so and so, so and so. First off, ordinarily, PIL jurisdiction is not permitted to be invoked where alternate and equally efficacious remedy does avail to the aggrieved. First off. Next, having heard the Learned Counsel for the parties and having perused the petition papers, we are broadly in agreement with the submission made on behalf of the respondents, and therefore we decline indulgence in the matter, reserving first off. Next, in the above circumstances, petition is disposed of, reserving liberty to the petitioners to work out their grievance as indicated above in accordance with law elsewhere. First, in that connection, all contentions are kept open and no opinion is expressed on the merits of the contentions.
Much.
Number 48. N. Shivkumar.
Application. Petitioner's application for deemed conversion of his land has been rejected, my lordship.
Deemed conversion.
Please.
Why
Lordship.
repetition?
Lordship.
Minerals.
Please, ma'am.
If it is conversion, it goes before the single judge.
No, here,
Why before the division bench?
under 95(9), Lord, it is for the purpose of quarry or crushing.
Then it comes before the.
It is covered by the
Covered by
judgment
the
of this. Since there is rejection, Lord, he has to file an appeal under 49 of KL.
To the appellate tribunal.
KLR Act.
Appellate tribunal.
In the similar circumstances, some court has entertained that.
You withdraw to file appeal or we discuss on the ground of availability of remedy?
To avail alternate remedy, statutory remedy is available, na?
On the rejection of, I may file a writ appeal, my lordships. But in the similar circumstances, the Sama court has entertained.
Challenge in this writ petition is directed against the order passed by Dispute 5, the Deputy Commissioner, Chikkaballapura District, Chikkaballapura. It is further prayed to direct the state respondent to issue the appropriate challan for remittance of the fine amount for conversion of the land prescribed under Rule 107 of the Karnataka Land Revenue Rules, 1966. Full stop. There is no gainsaying that the order sought to be impugned in this petition is appealable order, and appeal, statutory appeal is available under section 49 of the Karnataka Land Revenue Act 1964, paragraph. When the statutory alternate remedy is available in form of appeal, this court will not exercise the writ jurisdiction. Or there is no exceptional circumstance to entertain the prayer in the jurisdiction when the appeal is available.
Liberty may kindly be granted.
Petition is relegated to the remedy of appeal. It may be aware, this court has not gone into the merits of the case of the petition. Disposed of accordingly. So we'll say heard learned so and so, and learned government advocate Mr. Mahendra in the beginning.
Number 49.
Which the petitioners may not have sought for a writ of mandamus, my lord, to the fourth respondent municipal council, my lord, to take action, my lords, on the representations, my lords, which are filed by the petitioners for cancellation, my lords, of the lease deed, my lords, which is executed by the fourth respondent authority, my lords, in favor of respondent number 8 and 9, my lords. My lords, lease deed, my lords, this is the property, my lords, which is owned by the fourth respondent municipal council, my lord. A lease deed was executed, my lords, by the municipal council, my lord, in favor of the private respondent, my lord, 7 and 8, my lord, subject to certain conditions, my lord. My lords, in violation of those conditions, my lord, the respondent number 7 and 8, my lords, have put up construction without obtaining necessary permission, my lords, from the concerned authority. And also, my lords, one of the conditions, my lords, was that, my lords, the property, my lords, should not be subleased, my lords, in favor of any third parties. Having violated both the conditions, my lord, the petitioners, my lord, filed a representation, my lords, before the fourth respondent municipal council, my lord. The representations, my lord, annexure F and F1, my lords, if your lordship kindly peruses, my lord, the page 80, my lords, is the representation filed by the petitioners, my lord, before the fourth respondent municipal council, my lord.
So lease deed is executed in whose favor?
My lords, it is executed in favor of respondent number 7 and 8, my lord.
License is granted for legal. So both
They are
your-
the licensees.
They-
CL7 is granted to them.
My lords, excise license is now granted, my lords, in favor of 9 to 11, my lord. My lords, the 7 and 8, my lords, they sublease in favor of respondent number 9 to 11. Now 9 to 11, my lords, on the basis of the sublease deed, my lord, They have obtained, my lords, excise license, my lord, from the respond number 5 and 6 authorities, my lord. My lord, in fact, if your lordship peruses, my lord, the document at annexure C, my lord, and also B, my lord, at page 36, my lord. This is an endorsement, my lords, issued by the 4th Respond Municipal Council, my lord. To the effect, my lords, before executing, my lords, sublease deed in favor of Respond 9 to 11, my lords, there was no permission accorded, my lords, by the 4th Respond Municipal Council. And also, my lords, at annexure C, my lords, page.
CL7 is not yet granted.
My lords, now on the basis of recommendation, my lords, recently, my lords, it appears that
Granted.
it is granted, my lord.
You challenge it under the rule which you have held that
My lords,
anybody can challenge that.
please, my lords, our annexure, my lords, the representation, my lords, with regard to cancellation, the second prayer, my lords, is with regard to cancellation of liquor license, my lord. The first prayer, my lords, is regarding cancellation of lease deed, my lord.
Cancellation of these also they can put for the local. We have held that way already. We have already held.
My lords.
Even the grievance of the kind
Please.
can work out with the before the Lokaikta. It is covered under allegation, complaint as defined by the court in Natraj versus Dharma Singh. So very extensively decided. By law 2012.
Please.
Same. State and
So
Let's,
you can avail that remedy before the Lokayukt.
Let's, with
In respect of the first.
matters we have said. They should go before. You work out that, we'll give liberty to you, you work out that one. The
Only one-
second one, you can file the appeal.
Well,
We have
please.
held that appeal is maintainable
Please.
at the instance of non-party.
Please.
The public interest jurisdiction of this court is invoked in this petition, seeking the following two prayers, in Roman small one, bracketed portion, in Roman small two, bracketed portion. Full stop. As far as the grievance of the petitioner reflected in the prayer Roman small one is concerned, the remedy is available under the Karnataka Lokayukt Act 1984. Full stop. The prayer and the grievance can be agitated before the Lokayukt by making appropriate application. Full stop. In that view, since the petitioner has the remedy under the act, this court is not inclined to exercise the public interest jurisdiction. As far as the second prayer is concerned, it relates the challenge to the grant of license for running liquor shop by Dispatch number 5 and 6. Although the prayer
Applicable under section, liquor shop,
62, my lord.
62.
although the prayers mentions that
62
there
or
is only
16, my lord.
a proposal mooted for grant of the license, in course of the external advocate, Mr. So and so stated that now the license is granted, be as it may, paragraph, even in respect of this prayer,
61.
remedy under section 61 capital 61 of the
1960. Excise.
Excise Act.
Yes.
Karnataka Excise 1965 is available. Full stop. Any of the said statutory remedy available, the petitioner has to opt the said remedy, has to pursue the said remedy. Full stop. At this stage, learned advocate Mr. So and so states that the petitioner would avail such remedies in respect of both the prayers. Full stop. In that view, the petition is not entertained and disposed of, giving liberty to the
Please.
petitioner to
Please.
avail statutory remedies. So, in the beginning, we heard so and so, and learned the government additional.
Correct.
50 urgents number 51.
Page number 8. Para 7, page number 14, my lord.
51.
Page number
50 is group. 50 is group. Yes, what is the content?
My lord. Direction is the honorable division bench, my lord. Answer A, page number 8, my lord. Direction, para number 7 of page number 14, my lord. The execute scene when material on the record placed before us. The respondent number 4 has made out representation before the respondent number 2 KPSC and the same is pending consideration. For the respondent number 2 KPSC is considered the said medical.
Notice. Notice. Heard and negotiations, notice to the respondents returnable on reopening.
52 urgents number 53. Mr. A. Nagarajappa.
For my lord, difference in gratuity of amount on my lord period. What my lord, the controlling authority has entertained granted leave. The same was approved by my lord appellate authority. I succeeded before both the authorities. Permit single they dismissed on ground of
Inordinate delay.
There was it was an appealable order.
I have approached the appellate authority, original authority, appellate authority. Both of them have granted relief to the petitioner. The same was called in question by the case artist.
Within the time you have,
Approaching the original authority, there is a little delay in fighting the lord.
there cannot be delay condonation at all. That's how the Gujarat High Court has said.
Original authority, I succeeded, my lord.
That makes no
Difference in
sense.
gratuity of my lord, the amount.
Court have taken the view that once the period of limitation expires, no question of entertaining because there is no provision for condonation of delay. Gratuity.
These are the special acts were limited.
Special acts, yeah. Gratuity act. There is such a judgment. Section 7 or what? Which is that? Our original authorities?
Then the section.
7.
My application not came to the law.
That you have said twice. Seven one. Described is rules. There are rules.
That is due for the employer.
The section 7, my lord, the respondent about Transport Corporation of Federal Appeal for appellate authority. State appeal also came to the state.
So within 30 days to the employer.
Seven.
And controlling authority. sufficient for you. So, we'll
Just
postpone
look
it.
into and bring rulings in your favor. The rule says there appears to be
Power to condemn.
power to condemn also, but whether that application was filed, etc.
29(2) of the Limitation Act.
Huh?
29(2) of the Limitation Act. Wherever a special statute prescribes the filing within a.
It depends
Only
upon the
that-
language.
Only upon the special statute only.
Only for special statutes, wherever the Limitation Act is not expressly excluded,
Then
then Limitation Act applies.
Correct. Here it is express appears to be power to condemn.
If it is expressly excluded, the Limitation Act, that's what 29(2) says.
Limitation Act applies to the court. To the authority, the apex court said, in a case arising from Goa, if an entity does not fit into the concept of court, then Limitation Act is not applicable. Unless Special Act itself says the act is applicable. Not common.
Yes.
1st April.
Number 54, Mr. Vijay Ready.
But the complaint. Complied with. Leave the pension.
Comply,
Not complied.
not comply.
Notice. 4th April. 5th April. 5th.
Number 55. Nagaraj.
The disposal of the writ petition. the directed election should be conducted after compliance with the requirements of preparation of the electoral roll under Rule 13 D to A. Now the government has come out with a notification. May I just pass this on? The government has to come back with this. Now the government says that since the
Can I have a
parliamentary
copy?
elections is in the annual, is in the annual, it will not be possible for us to take over the managements. So what we are doing is, in respect of all those societies for which the term has come to an end, we dispense with the applicability of 28A4, which ceases the moment the term comes to an end. Then 28B and 29F4, existing body shall continue till the next elections are conducted. Let me just read that particular portion. Yesterday they have done it. I could get the copy today.
But whether that can be done, the
Let's-
provision says.
121 of the Cooperative Societies Act provides, because if the general elections are there, it's then conducting the elections for the cooperative societies.
No, that's all right. Elections may not be conducted, but there is one provision which you had argued before me.
28A4. 28A4.
Where, it should be taken over by the concerned authority.
That's what
It's
is.
in your matter.
Yes. I had argued that matter, my lords. Lords, may I kindly see that?
Administrator. By operation of law, it goes to the.
Lords, now that is what is done presently, my lords, in the government, because this is the view taken by the government. The government will have to take a stand. If the government says that this is what is the understanding with which. Pardon me, lords.
We are extending the period itself.
Extend.
It cannot, we will not take note of that unless you show that it elects to stand.
121 of the Act, my lords, of the government is powers.
To give direction.
Yes.
That is not covered.
Extension of the term of the.
That amounts to government sitting in.
No, my lords,
electoral
it
process.
is permissible for the government to exempt the operation of certain laws to certain societies. Section 121.
Term is 5 years,
Term is 5 years.
no longer.
Lords, now there is a direction to hold. Lords, our grievance before the
No
court
longer
was.
is,
no
no
longer
longer
what
is
is
also mentioned, I think in a constitutional provision.
In that,
The
here we
constitution
don't.
says no longer, no, even for cooperative society.
Lords, cooperative. your
No
lords,
longer is
yes.
that word is there.
Cooperative is
Lords-
also under part of. the
Yes, yes.
new
Lords, but
CA.
part 9B stood struck
9B,
down.
9B.
In Rahul Shah's case, the part 9B stood struck down. But nonetheless, my lords, the
9B
legislative
is struck
competence
down by Gujarat.
by the Supreme Court confirmed in Rahul Shah's case.
Entire 9B.
As Gujarat High Court had set aside, and then Supreme Court confirmed in Rahul Shah's case. Section 121, my lords. The
No,
state
which is-
government.
Which I remember having read, now my memory is playing a trick with me. Now, there is one section which says shall be only for particular period and not beyond. Such.
28A4, my lords.
28A4. Yes.
Then
No, they cannot do
answer.
that. Go to the election.
The term is provided in 28A. Term of the society.
Now 28A4 is exempted for those societies whose term is coming to an end or whose term is completed.
Where is that? Management of the society. No. Where is the tenure?
Tenure section is?
My lords, tenure is section 28B.
28B.
It's 5 years. 28B2.
Deemed to have vacated.
Yes, my lords, deemed to have vacated. Now 29A1, my lords.
29A1.
A1. Commencement of term of office. The term of the office, members of the board shall commence on the date on which the majority elected assume office or term of the office is later, notwithstanding anything contained or the rules so and so, the majority of the elected
So
members.
that is buttressing the.
Yes, this is commencement of term.
Such provisions cannot be. Even if those provisions are taken, that's not the amount extension of the period.
Lord, that is what, if your lords were to see the notification, lords, it's of course.
No, we'll assume now.
Yes.
We will assume you are 100% correct now. Just we are saying the legal effect. You are exempted from those provisions. Does it mean that the popular mandate is elongated by that?
That's exactly what the government circular says. Not see if the government has taken that stand, where the
we will not
administration of the
take,
cooperative society.
If you want to withdraw. But if you want to argue, we will write that way.
Not sir, I will certainly argue the matter, my lords.
All right.
Please.
My lord,
That's only a subsequent fact which I brought your lordship's notice, but the grounds on which I am before your lordships is entirely different.
my lord, could I get the learned advocate general, my lord?
Just come. Your period is over now.
Lords, the grievance with which we approached the court, even before our term was over, was that they are delaying the process of election. That is the grievance with which we went before the learned single judge. Now, the government came and said that 13D 2A notice which has been issued is not in order, though the notices were issued.
Yeah.
We only said, let there be a time fixed for conducting the elections.
Correct.
Because in the interregnum, when the writ petition was pending, the term of the board came to an end and administrator came to be appointed. We have no grievance. We have not challenged the appointment of administrator. We knew the legal effect. But our only grievance is that there should have been a time limit because this is a
time limit for
conducting the elections.
That's true. If suppose some meteor comes and fire hits the earth,
yes,
this impossibility.
Lords, now the question is this: the kind of societies with which Lords, we are dealing, it requires a day-to-day functioning Lords of the board. This now if the officers
for
are
administrator.
Lords, now the administrator will be an officer
Already
who is entrusted with Lords, he is there.
It's
already appointed.
no the operation of
My lord, is the
no
connected.
question of appointment.
Maybe, but he is now in charge of the society.
Lords, the only
So
grievance.
what do you want from us now?
Lords, we are only saying that the election should be conducted within a period of 60
That is
days.
started. That is also started. The Advocate General made a statement before learn a single.
Yes, Lords,
That
we are
they
only
started
saying.
the preparation.
Lords, we are saying that once the notices are issued, then the elections are required to be conducted within a period of 60 days. The reason is 13D 2A says the period within which the notice is to be given, objections is to be entertained, and the period within which the list has to be finalized 15 days prior to the date of the election. This entire process takes about 60 days, Lords. It cannot spill beyond because the object of the Cooperative Societies Act is to have a body elected by a popular mandate, not by the state administrator. any exigency which is sought to be put forth, my lords, by the state saying that this is an exigency, therefore we don't want to conduct the election, is not the kind of exigencies covered under the scheme of the Cooperative Societies Act. And further, if your lordships were to see that there is a time fixed for an administrator to conduct the elections after he takes over. 28B. Lordships may kindly see section 28A. 28B. 28B3. Administration charges also. May I request your lordships may kindly take 28B. May I request your lordships may kindly take 28B subsection 3, which mandates that from the date on which the administrator takes charge, maximum period within which the election should be conducted 6 months, not beyond.
Correct.
That's all what I'm asking.
6 months will be expiring when?
Lords, that 6 months is already, that will be October 2023, the administrator is appointed.
October, November, December, January, February, March, April.
April.
by
Ashke
that
ನಾನು
it
ಏನು
will be-
ಕೇಳ್ತಾ ಇಲ್ಲ. I'm only asking that, let them conduct the elections. 28B3, your lordships may kindly see, lords, how the mandate runs. Lords, this is a case where an administrator assumes charge under 28A5.
Correct.
Because the term of the board has come to an end under 28A4. The administrator who shall assume charge under subsection 5 of section 28A shall as early as possible, but within period of 6 months, arrange the constitution of a new board of the society in accordance with the act, rules and the bylaws.
Learned government, learned advocate general will come before the court and make a statement that within such and such time we'll hold the election.
Why you assume that they will not do?
My lords, the reason why I am before your lordships is the learned single judge says, let the election be conducted on 4/7/2024, which violates the mandate under 28B3. It can never be spilled beyond 6 months. The statute does not provide. You know, there are other provisions which says that the term of an administrator or a special officer may be extended by a period of further 6 months. These provisions are there in the other provisions of this statute. But so far as administrator taking charge under 28A5, which is the present scenario, no question of further extension. 6 months is mandatory. March, April.
Within the statutory period, you conduct.
Let them conduct. That's all the
election.
grievance.
Lord, a minute, learned advocate general will come and.
But your contention that you should be permitted to run the show.
Lords, this is not what I said.
What government has
What
said.
government
What
has
will
said.
make since you have produced it, we will say it cannot be.
I've
Otherwise, nobody, no society will be safe. All funds will go into the electoral process. Not this party, that party.
My lords, now I will just put this across, my lords, in respect of a credit structure society, my lords, particularly like the DCC banks, the board functions on a day-to-day basis because every day there will be dispersal of loans. These are all the loans which are being sent through the VSSN because there will be funding from the monetary fund. So these kind of boards are required to function regularly. So far as these boards are concerned, my lords, to substitute with an administrative officer expecting him to disburse the loans because withdrawal of deposits and all, so many banking issues will be there.
But you are not challenging the section.
That's no difficulty, but under 28B3 itself, your lordships may kindly see, so far as credit structure society is concerned, 3 months.
Correct.
So
That's
therefore,
not your case.
no,
Your
no,
case is
there
not
is another matter, my lords, where I'll be.
Eagerly await.
I'm sorry, I just came to.
There is.
Copy government circular.
Elections to be conducted.
What? Can I seek instruction first thing tomorrow morning, my lord? If, because without instruction, first thing tomorrow, morning, 10:30.
But we are putting it across.
Please, my lord.
How the government can elongate the period, statutory period of a popular body.
That's
A
correct.
popular body is constituted on the basis of popular mandate.
Correct.
Mandate is for a specific period.
Please, my lord.
Can the government say, no, the mandate is extended in the absence of an enabling provision? Government has power to say that some of the provisions of the act should be insulated and kept in abeyance. But where is the extension?
I understand, whether if it's for a period of 5 years,
Now administrative is functioning.
administrative functioning.
Extended the tenure also. They are producing. Council.
I'll just seek instructions and I'll find.
Order.
Yes, my lords.
I'll seek instructions. Your lordships
I've-
are saying, you know, if the period is for a period of 5 years, it cannot be extended one day beyond period of 5
Yes,
years.
section
just-
says.
In fact, earlier that Mysore, Chikmagalur.
Same, that's what you have argued.
Morning,
Huh?
which we have pointed out.
That was your argument. We upheld that.
Please, ma'am. I'll just get back first thing. I'll verify this.
He was also there.
It's on both the sides. ma'am. If you don't, if it's.
But he is engaged in both the sides. What to do? So popularly.
Certain proposition of law are so
Clear.
strong that you can't. And this is one of them, that
One.
you can't elongate the
No, that's the first
term of the
principle.
office of the elected.
Let me understand what they propose to do in this, my lords. I'll make submission.
ಇದ್ರಲ್ಲೂ ಏಪ್ರಿಲ್ ಅಲ್ಲಿ election ಆಗ್ಬೇಕಷ್ಟೇ, ಇನ್ನೇನ್ ಹೇಳಕ್ಕಾಗತ್ತೆ. ಗೊತ್ತಾಯ್ತು.
Mr. Advocate General, tomorrow or day after? Monday.
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 ಇರ್ತೀನಿ, ಮಂಡೇ ಇರ್ತೀನಿ.
Monday, madam.
Monday.
Monday.
58 ನಂದು.
Monday.
Next matter also is the same problem, my lords. 56 is exactly the same issue.
Please, Monday.
Lordships. ಫಸ್ಟೇ ಬರ್ತೀರಾ ಮಂಡೇ 10:30ಗೆ? Can we make a mention at 10:30 when the Advocate General comes, my lords, on Monday?